Good morning, Committee Secretary. Good morning to everyone on the platform. Can I check whether we are correct, Committee Secretary?
Chairperson, we do correct, Chair. Shall I do the roll call, Chair?
Yes, please.
Mr. Mbuyani.
Good morning, Chairperson. Good morning, colleagues. I'm present. Thank you very much.
Good morning.
Recording in progress.
Mr. Malamatia, Chair.
Good morning, Chairperson. Good morning, colleagues. I'm present. Thank you.
Good morning.
Mr. McPherson, Chair. He's on the platform, Chair.
Yes,
No, I am here. Sorry, I was just trying to unmute. I'm available. Thank you.
Thank you. Good morning.
Ms. Mwatse.
Good morning, Chairperson, and good morning, everyone. I'm present.
Good morning.
Mr. Monakedi. He's on.
Good morning, Chair. Good morning, colleagues. I'm present.
Good morning.
Mr. Mulder.
Good morning, Chair. Good morning, all. I'm present.
Good morning.
Ms. Gronyana.
Good morning, Chair. Good morning, everyone. I'm present.
Good morning.
Chair, those are the members currently on the platform. The others still may join us, Chair, and I will keep you posted on that. Thanks.
Thank you. Can we flag the agenda, please? Thank you. Do we have any apologies?
Chair, I don't have apologies at the moment, Chair. The others may still join us, and I'll keep you posted if I receive any apologies during the course of the morning, Chair. Thanks.
Thank you.
Mr. Thring just
We
joined
have
us.
the agenda. Sorry?
Mr. Thring's just joined the platform as well, Chair.
Okay.
Thanks.
Good morning, Honorable Thring. You're welcome to the meeting. Can we have a move and a seconder for the adoption of the agenda as flighted? Members? Honorable Moatse.
Thank you very much, Chair. I move for adoption of the agenda as presented.
Thank you. Can we have a second, Honorable
Monakedi, Chair.
Chair, I want to second the proposal for the adoption of the agenda. Thank you. Thank you.
Thank you very much. So members, the Companies Amendment Bill and the Companies Second Amendment Bill was introduced in September 2023 in Parliament and referred to the Portfolio Committee for Trade, Industry and Competition for its consideration and report. In order to facilitate the public participation in the legislative process as required by law, the committee placed adverts in print and social media calling for public comment on both bills. The committee received 41 substantive submissions as well as smaller submissions from the public in this regard. Public hearings on the above-mentioned bills have been scheduled for over 3 days. Therefore, the purpose of the meeting, today's meeting, is to receive oral submissions from stakeholders identified by the committee. As public hearings are held on a virtual platform, it becomes vitally important that stakeholders comply with the requests communicated by the committee secretary, which is, first of all parliamentary rules in relation to hearings will apply. Number 2, the chat room is for use by members only, staff of Parliament and departmental officials only. Failure to comply may result in removal from the platform. Each stakeholder will have 15 minutes to make their presentation, followed by a 20-minute engagement. Number 4, stakeholders are reminded to switch on their videos when they present, if they are able to. When you have completed your submissions, you are free to leave the platform if you so require, or you are welcome to stay for the duration of the stay. the public hearings. So our first presentation today is from Business Unity South Africa, and I think Mr. Govadia is the presenter. Mr. Govadia.
Thank you, Madam Chair, and thank you to members of the committee for the opportunity to present our oral submission. The committee does have a copy of the submission, and I will go through the submission fairly quickly so that we have more time for questions and comments. I'm not going to spend too much time on what Business Unity South Africa is. It is the business organization that represents most of business, and we represent probably 90 to 95% of the economy through the representation of various sectors and other members. Next slide. We welcome the opportunity to present on the bill. We recognize the intent of the bill to enhance investor confidence, to strengthen governance, and to protect the interests of shareholders. It's also to simplify the compliance procedures and will make it easier for businesses, particularly small business, to operate efficiently, and that the bill is intended to enhance the regulatory framework for businesses. Next slide. Some general comments. We believe that some provisions do have a particular impact on small business and may overburden small and medium-sized enterprises. There is complexity and ambiguity in some provisions of the draft bill, which leaves room for interpretation, and this could result in legal challenges. And we believe the committee should try to clarify those issues. There is increased regulatory oversight through the bill, and this may be perceived to be excessively intrusive and interfering with the affairs of businesses, and may dilute value created by voluntary corporate governance practices, which are in place in many major businesses. Provisions on shareholder rights may lead to shareholder legal disputes and the disruption of operations of businesses as far as shareholder activism is concerned. And we do have some concerns about data privacy, where provisions related to the collection and sharing of corporate data have raised concerns on vulnerabilities of data privacy and cybersecurity. Next slide. The implementation period for the transition is unclear and presents risk for companies, and we need clarity on that. We believe there are some unintended consequences, as the provisions may have some unintended negative impact on the operations of businesses. Enforcement challenges, there is a risk of inconsistency in enforcing the legislation, as authorities may not have the necessary capacity to enforce the bill. Consultation with stakeholders, we believe more consultation is required before finalization of the draft Companies Amendment, but to ensure that we don't have a negative impact on business. Next slide. We then have some specific comments, Chair, on specific sections of the bill. On Section 26(1), which is access to remuneration information, our concerns are that the proposed amendments will enable members of the public to access complete AFS of private companies over a certain public interest score for the preceding 7 years. We believe that that's onerous. Information contained in the annual financial statements may be made available to a company's competitor suppliers, and this may have negative consequences. In holding group structures, financial information of subsidiaries may be consolidated into the financials of a listed entity. This may provide ready access to price-sensitive information and may result in the prohibited act of sharing of price-sensitive information. And ready access to named director remuneration of private companies, including subsidiaries of listed companies, would constitute sensitive information which may violate the privacy rights of named directors and expose confidential information to competitors. So there are a number of information issues and confidentiality issues that we are concerned about. Recommendation is that private companies that are part of a listed company which already publishes its annual financial statements should be exempted from the proposal made in Section 26. And alternatively, Section 26 should be clarified that the right to access of company records of a private company should be limited on the grounds of reasonableness and appropriateness and should exclude access to the annual financial statements. Next slide. Then on Section 30A1 and 30A2, our concerns are it's unclear whether the requirement for the approval of the remuneration report by shareholders applies to public companies that are subsidiaries of holding companies. And we are concerned that the requirement for the remuneration policy to be approved through a resolution of the AGM may not be practical, resulting in delays in implementing the policy. Our recommendations: public companies that are subsidiaries of holding companies should be exempt from presenting a remuneration report. And we recommend the amendment to Section 38(2) to allow the board to convene a special general meeting to approve the remuneration policy. Next slide. Then on Section 38(3), disclosure of the remuneration policy. It's unclear whether the disclosures with respect to employee remuneration should be limited to permanent South African employees only, or whether it should include temporary employees, contracted employees, and employees located outside of South Africa. There's a lack of clarity on whether employees who commence employment mid-year should be included, and the remuneration of senior executives as reflected in the salary record on a cash flow basis, as currently required in the Companies Act, is highly variable and influenced by prevailing company performance and share prices, which makes it subject to volatility and difficult to use as a meaningful reflection of actual remuneration. The recommendation: it would be preferable to report the pay gap on the basis of on-target remuneration, which is more indicative of the intended policy outcomes, and the disclosure guidelines should be aligned to EEA4 reporting requirements. Next slide. Then on Section 38(3) and 38(3)(e) and F, disclosure of lowest paid employees and the median and average and 5% highest to 5% lowest remuneration. There is concern that the remuneration information may be misinterpreted if the correct context is not provided. The basis for the 5% pay gap measure seems to be arbitrary. There is no clarity on how contracted employees would be treated, and actual remuneration may be misleading in determining the pay gap, as employees may join and leave the organization mid-year and not realize the full value of the allocated remuneration. Recommendation: practice notes should be included in the disclosure requirements to provide clarity and misinterpretation. The use of the Palmer remuneration ratio, which is the gap between the top 10% and the bottom 40% lowest paid employees, is preferable from a policy perspective because there is substantial academic research in the developing economics that it is a more effective method, and on-target remuneration should be the basis for any pay gap comparison calculation instead of actual remuneration. Next slide. And Section 30A(9), consequence for the implementation report not being approved by shareholders. We do not support the proposal that the non-executive directors serving on a remuneration committee must step down from the remuneration committee and may not be eligible to serve for a period of 3 years after such non-approval, the one-strike rule. We believe it's increasingly risky for directors who serve on remuneration committees, and this will further deter people from serving. This does not bode well for the proper functioning of the remuneration committee. Directors with skills and knowledge are not easy to replace, and South African companies already experience a shortage of directors with those skills. Recommendation: the implementation report should not be subject to a binding vote, in our view. However, should it be subject to a binding vote, we suggest as a proposal in respect of 30A(9)(e) be retained as the exclusive remedy to an instance of a vote against the implementation report. The chairperson of the Remuneration Committee stands for re-election every 3 years as a means of good practice and governance, and a non-binding vote on the implementation report, that is not a binding vote, with compulsory consultation in case of a vote of more than 25%. If this is not adequate, we propose the two-strike rule be applied. Next slide. Then Section 30A, limitation of remuneration committees. In our concern is that the ineligibility of non-executive directors serving on the remuneration committee to continue to do so for a period of 3 years after a single vote of non-approval is a significant departure from King 4. The 3-year frequencies proposed in the bill of the remuneration policy vote will limit engagement on remuneration and reduce the pace at which policies can be improved. Limitation placed on remuneration committees will make it difficult for companies to secure and retain skills, and a binding vote on the implementation report is not in line with international best practice. Our recommendation, the bill should legislate the current process that is in place as outlined in the JSE listing requirements with regard to 30A, 4, 5, and 6. 30A should differentiate between listed companies, state-owned companies, and public companies, which are subsidiaries of holding companies, and voting on the remuneration policy and the implementation report should be of a non-binding nature and aligned with the King Code, where the threshold is established in relation with the vote against the resolution. Next slide. On Section 33, access to annual financial statements, our concern, the bill proposes amending Sections 26 and 33 of the Companies Act, such that the AFS of certain private companies and all related information be declared public information. We are concerned about that. Provision within PAIA already make it possible to access such information through a legitimate process. The amendments may be in conflict with privacy laws and may violate information exchange guidelines of the Competition and the Competition Act. We recommend that as a matter of principle, the information of private companies should not be made public, particularly when the information is already available to institutions such as the regulators. The AFS should not be made publicly available without application of the PAIA provisions. Where information has to be provided, companies should be empowered to redact any competitively sensitive information, and alternatively, and in line with international trends, companies could be required to disclose pay ranges when vacancies are advertised. Next slide. 61.8, appointment of Social and Ethics Committee. That section read with 61.7 makes provision for the appointment of a Social and Ethics Committee and the compilation of a Social and Ethics report by a public company. Section 72.4 gives the minister the power to determine which companies should appoint social and ethics committees. The proposed new amendment in 61.8 seems to suggest that all public companies must have a social and ethics committee, which is not currently required. Our recommendation, the confusion created can be clarified by adding the words "where required" in terms of Section 72 in various parts of Section 61.8. And clarity is requested in respect of the obligations of special purpose vehicles, which have no employees or management, as these companies should be exempt from establishing a social and ethics committee. Next slide. Section 72, composition of the social and ethics committee. It's not clear whether 72.7a(b) is intended to require that at least one of the members of the committee of a private company must be an executive director, or the intention was for one member to be a non-executive director. Recommendation is that the composition of the Social and Ethics Committee should be clarified in line with the recommendations of King 4, allowing for majority of committee to be non-executive, with its majority being independent, and allowing an executive director to be a member of the committee. Next slide. Section 90, requirement of AFS. Proposed text is unclear on the timing of the shareholders' meeting that is convened after which the requirements were first applied. This creates the incorrect impression that the requirement is applied at the shareholders' meeting. This is not the case in all instances, as the requirement should be an operation under law under 84C1. Recommendation suggested amendment that at the shareholders' meeting convened for this purpose after at which the requirement first applies to the company and annually at the shareholders meeting thereafter be inserted. Next slide. Section 118, definition of indirect shareholding. We're concerned about the concept of indirect shareholding is not easily understood and is an undefined term in the Companies Act. And as the proposed definition stands, it would not be clear if the intention is, for instance, that all shareholders of the registered shareholder company are indirect shareholding of the issuer company, and it is not clear how far up the chain must go to ascertain so-called indirect shareholders. We recommend that the concept of indirect shareholding should be defined and clarified to refer to the beneficial shareholders of the shares which are registered in the name of the nominee or fiduciary entity. Next slide. That's it, Chair. Thank you very much. Tried to run through this as quickly as possible so I have to leave time for questions. Thank you very much for the opportunity.
Thank you very much, Mr. Govadia. You are very accurate with your time. Members, that's the presentation from BUSA. Can we have interactions, if any, with the presentation? I'll take hands from committee members. Honourable McPherson.
Chair, may we ask them for BUSA to stop sharing the document, Chair? Thanks.
Okay, thank you. Please stop sharing. Thank you so much. So it's Honourable McPherson and Honourable Thring so far. Honourable McPherson.
Thank you, Chair, and thank you, Mr. Govadia, for the good presentation. I just want to get your comments or thoughts around what may be perceived to be onerous over-regulation, particularly with the matter of the Remunerations Committee. Now, one has seen the en masse delisting on the JSE over the last decade. I think that there was a report published that there were 700 companies on the JSE 10 years ago. There's now 294. Now, I mean, obviously the JSE has their own requirements in terms of publicly listed companies. Do you think that these requirements will further speed up the delisting of companies from the JSE? On the issue of private companies publishing financial statements, do you think that this would not be an excessively expensive and further cost of doing business, particularly for private businesses? And do you think that it actually may risk competitiveness between private entities? And then also your views on the Social and Ethics Committee. And as you said, that would be via regulation from the minister. What size business, what size private company should do you envisage that a Social and Ethics Committee would relate to? Would it be a blanket application, or do you think that there would be thresholds that should apply in terms of turnover or company size? Thank you very much, Mr. Govadia, and thank you, Chair.
Thank you, Mr. Govadia. We'll take all questions and then we'll give you a chance to respond. Honourable Thring.
Thank you, Chair. Chair, maybe just from my side, 2 or 3 questions and perhaps just a comment. I want to ask Mr. Govadia to please, if you could just expand on what he would see as the negative effect of the bill on small business. I presume that it's the onerous nature of the bill and giving small business more, instead of focusing on the business, it's kind of more administration that they would need to actually deal with. But if you could just expand a little bit on that. And then secondly, give more information on the Palmer ratio, which is recommended to be used as a tool to determine the gap between, I think it was the top 10%, bottom 40% within a company. And then maybe just my final question, I think he did indicate that he sees the intent of the bill, but in its current form, obviously with all of the recommendations, that have been made, would you recommend what effect do you think the bill would have on business in its current form? Thank you.
Thank you, Honorable Thring. Honorable Malamacha.
Thank you, Chair. Allow me to also have a bite to say on the issue of enforcement. You sound very negative in a manner that you are saying the state, if not the authority, might not be equals to task. Would you please explain that so that we get to understand that in the process of amending and developing, then if such casted doubts are coming in and out, how do we really take the country forward? Would you please elaborate on that? Thank you.
Thank you. Those are all the hands I see at the moment. Back to you, Mr. Gubadia.
Thank you, Chair. I'm going to respond to some of these, and then I'm going to ask colleagues who are on the line to put up their hands and respond to some as well. So there's been a number of questions on whether the bill is onerous and whether that would impact on companies on the JSE, whether more companies will leave, and the impact on private companies, why we're saying that that would be onerous as well. I think what we're saying is that in the current context in South Africa, where the focus has got to be on encouraging businesses to grow, to develop, and to create jobs, and to encourage new businesses to be formed, where within a context that is already difficult for businesses, because we don't have, in our view, the environment to promote investment and growth, and that is why we're doing a lot of work currently with the presidency on critical issues like energy, logistics, and crime and corruption to try and create that environment. Where that environment, broad environment, is already difficult, to put into place legislation that brings about more onerous responsibilities, reporting and other responsibilities on businesses, we believe is counterproductive. What we believe legislation should be doing is, one, recognizing existing pieces of legislation that already allow for some of these disclosures to happen through proper procedure, to not duplicate that, and then to look at how the intents of the bill can be met in ways that don't put onerous responsibilities on business, that we actually allow businesses to get on with their businesses, to create jobs, and to have legislation that enables proper disclosure, enables proper practice, but does not duplicate legislation that's already in place. And for private companies, I mean, the private companies are very often family-owned and other sorts of companies, and to put the sort of onerous responsibilities on private companies that could also be put on public companies, we believe is inappropriate. On small businesses, and I'm going to ask some of our colleagues to come in on the Social and Ethics Committee. On small businesses, again, we've recognized as a country that we need to promote and build small businesses. Currently, we have amongst the highest failure rate of small businesses in the world. And to put responsibilities on small businesses that detract them from actually concentrating on the running of their businesses. And they don't have large compliance departments and legal people working for them to deal with these requirements. We believe, again, it's counterproductive. And the bill needs to consider that. On the Palmer ratio, it's a measure of inequality that divides the share received by the richest 10% by the share of the poorest 40%. Higher values indicate higher inequality. Inequality is measured here in terms of income before taxes and benefits. So that's the Palmer ratio, and we are suggesting that a more accurate measurement of differences in remuneration. So, and then the final thing I'd like to address before I ask others to come in is that when we say the state may not have the capacity to implement, again, it's a matter of public knowledge, and it's not just Busa saying this. It's a matter of public knowledge, and from the president down, government people have been saying that the state does have capacity issues for various reasons, and I think that the capacity that is available in the state should be utilized to actually attract investment and grow the economy, and do everything we need to do that, because that's got to be our focus. And so, as far as we're not saying that as a result of the lack of capacity, the country can't move forward, but we're saying let's utilize that capacity and let's focus that capacity on attracting investment and creating growth, because that's what we need to actually address both the social and economic problems we have. And business stands ready, as you know, Madam Chair, as we are already doing with the presidency, to mobilize capacity to donate to government. And we will continue to do that. I think that capacity needs to be focused and utilized to grow the economy and to attract investment. Do colleagues want to come in on adding on some of the stuff I've said, and to talk to the Social and Ethics Committee, and anything else you want to add? Mike Juden, others? It appears I've covered it, Chair. Nobody is putting their hands up.
Thank you very much. Oh, there's
Oh,
Mike.
sorry, Mike Juden. Sorry.
Thank you. Madam Chair, honourable members of the committee, and Cass, thank you very much. In the interest of time, I'm going to be very brief. Firstly, may I, through you, Madam Chair, compliment Cass on what I thought was an excellent presentation, and which reflects not only Busa's views, but also our delegation to NEDLAC. Very briefly, what I want to say is that as a practicing commercial lawyer, somebody who's been involved with the writing of the King committees, the King reports throughout, and also having been involved indirectly when we were writing King 3 with the Companies Act, we have what is universally recognized as an excellent Companies Act. King 4 is universally regarded as the world's leading corporate governance code. I think we should be very careful about amending where it's not necessary to amend. I think we should amend only where it's absolutely essential to amend. And I just want to, in conclusion, underline what Cass said. The most critical issue facing this country is for us to help small businesses to be created, to operate, and to prosper. Please let us not impose burdens upon them, which are going to make it even more difficult to do so than what it is at the present. Thank you to members of the committee for your hard work, for giving us this opportunity, and I wish you the best of luck in your deliberations. Thank you, Madam Chair.
Thank you very much for those warm words. You have about 5 minutes left, Mr. Govadia. Is there anything you want to add in conclusion?
No, Madam Chair, I think just at the risk of being repetitive, just to say that, you know, like most pieces of legislation and amendments to legislation that government puts on the table, we agree with the intention. And we agree with the direction in which this amended bill wants to go. All we are saying is that let us recognize the broader context we are in as a country. And certainly from business's point of view, our view is that our focus as a country has got to be on investment and growth. If we get the investment in, if we create the environment for investment and make it easier for businesses to actually do ethical and responsible business, and let me stress that, then we can, on the back of that investment, work together to grow an inclusive economy. And again, let me stress inclusive. And that legislation, proposed legislation, needs to be tested against that and needs to promote that. So in meeting the objectives of the amended bill, what we are emphasizing is that please test the outcomes of the bill against that and ensure that the legislation facilitates investment and business growth and does not hamper it. Thank you very much.
Thank you very much. That concludes the input by Business Unity South Africa. We'll go to the next presentation, which is from the Johannesburg Stock Exchange, Dr. Fourie.
Thank you very much, and good morning to everybody, and thank you for giving us an opportunity to put our position forward. We're deeply appreciative of this and our ability to present our submission of the Companies Amendment Bill to the Portfolio Committee on Trade, Industry and Competition. I'd like to introduce my team, Andre Visser, who is the Director of Issuer Regulation, and Clayton, our Group of Public Policy and Regulation, and Louis Cochrane, our Legal Counsel. The JSE has a very well-established history of operating as a marketplace for raising capital and trading financial products. And the JSE is currently ranked in the top 20 stock exchanges in the world by market capitalization. And we are the largest stock exchange by a very long margin in Africa. And we've been in operation for 136 years. The JSE is very much at the center of the South African capital markets, and we are the prime platform for financial trading and capital raising in South Africa. We process 98% of all value traded on listed counters. The JSE connects global investors through our platform, which is really designed to deliver very secure and efficient primary and secondary capital market access across quite a wide, diverse range of securities. And this is supported by our post-trade and our regulatory functions. And this really makes the JSE the market of choice for investors who are looking to gain exposure to South African markets. That's international investors. And this would be both for local and for international companies to raise capital. From a listings perspective, the JSE acts as the listings authority, and we are licensed as an exchange in terms of the Financial Markets Act. The JSE's regulatory duties, powers, and functions are narrowly circumscribed by the peremptory provisions of the FMA. And in accordance with the FMA, the JSE is obliged to make listings requirements and to enforce them. So in many ways, we are part of the Companies Act ecosystem. The JSE recognizes public concerns around high inequalities in our society, and we very much support better disclosure of senior executives' remuneration and the reasonableness of remuneration, and also, of course, the pay gap transparency. We believe that these provisions will assist the public dialogue on this topic. We support the provisions regarding a binding vote on remuneration policy, but we don't support a binding vote on the implementation report and the stand down of directors. I'm going to hand over to Andre Visser, who is our JSE Director of Issuer Regulation, and he will present the reasons for our opposition to the provisions relating to the binding vote on the implementation report. Andre, over to you.
Thank you, Leila. Good morning, Honourable Chair and Honourable Members. Thank you for the opportunity to present the JSE's position this morning. As Leila mentioned, the JSE is fully supportive of the policy of disclosure of executive remuneration and the reasonableness thereof. But I think in order to put our opposition to the binding vote on the implementation report into its proper context, it may be helpful to just give the committee some context as to the transparency and accountability framework that we've got in place for JSE listed companies as it relates to remuneration at the moment. I think it's very important to see that in context. There's 4 cornerstones to that transparency and disclosure accountability framework in our rules. I think to start off with, it's important to emphasize that the JSE has a listing requirement in place that stipulates that all directors of listed companies must be appointed by shareholders. The reason why it's worth emphasizing that point is the fact that it's in addition to the provisions of the Companies Act that stipulates that only 50% of directors must be appointed by shareholders. So in terms of our rules, shareholders have significant rights and powers in terms of determining who is the directors of the company and who's in charge of governance of the company. So we afford a very powerful right to investors on appointing directors. I think the second point that's worth emphasizing, Honourable Chair, is the fact that in terms of our listing requirements, we also stipulate that all non-executive directors must rotate and stand for re-election at the annual general meeting of companies. So what we stipulate is that 1/3 of all the non-executives must stand for re-election every year at the annual general meeting. Now, why this point is so important is that when we talk about the Remuneration Committee members stepping down, it's important to emphasize that in terms of the listing requirements, JSE listed companies, shareholders essentially have the ability to vote and decide whether Remuneration Committee members should continue serving on that particular committee, and they can vote them down over a 3-year period, essentially. Again, a very important and a powerful right that we afford to shareholders. The third point that's worth emphasizing, Madam Chair, is the fact that the JSE was at the forefront of disclosure and transparency of executive remuneration when, as far back as 2002, we decided to impose mandatory disclosure obligations of individual directors' emoluments through the listing requirements. So we were certainly at the forefront of raising transparency and disclosure on remuneration. And then I think the fourth cornerstone of this disclosure and accountability framework relates to a provision that we introduced in 2017. Michael Juden spoke about the importance of the King Committee and the King Committee being at the forefront of corporate governance best practice. And what the JSE did in 2017 is we introduced a recommended practice from the King Committee into the JSE listing requirements. And that was the practice that all listed companies had to present, firstly, a remuneration policy, and secondly, a remuneration implementation report at each annual general meeting, with the accompanying obligation of them to put a vote to shareholders. It's a non-binding vote to shareholders, where shareholders can express their view on both the remuneration report, the policy, and the implementation report, with very clear consequences that if it's voted down by 25% or more of shareholders, that it relates or strikes the provision that companies are then obligated to engage with shareholders on that score. So, Honourable Chair, I think important to see that sort of 4 major principles that we have for disclosure and accountability for JSE listed companies in context, and that will give you some perspective as to why we opposed to the binding vote on the implementation report only. Honourable Chair, I think from a JSE perspective, the disclosure and accountability mechanism that I've referred to just now provides shareholders with significant rights, provides them with an opportunity to engage with the company if they are dissatisfied with the remuneration policy or the implementation report. And I'll speak later on in a bit more detail about where we think some of those benchmarks and mechanisms can be strengthened. So in summary, on this particular slide, Honourable Chair, in our view, a binding vote on the implementation of an approved remuneration policy introduces uncertainty, it brings lots of complexity, and in our view, an unnecessary burden on our JSE listed companies, which defies the ease of doing business policy, and in our view, would impact on the attractiveness of South Africa as a capital raising destination. Next slide, please. Honourable Chair, if I move on, just to highlight, certainly in our view, if you look at the extensive rights that we afford shareholders in terms of the JSE listing requirements, it remains our preferred approach that the implementation report must remain subject to a non-binding advisory vote. We're not opposed to codifying the provisions that I've referred to in my previous slide in the primary legislation, but we remain opposed to a binding vote on the implementation report, and very importantly, the stand down of the Remuneration Committee members as proposed. And I'll briefly give the committee some context for the main reasons why we are opposed to that. I think firstly, it's certainly our understanding that there's no other country in the world that has a statutory imposed binding vote on implementation, coupled with the consequences of an immediate step down of Remuneration Committee members, where a resolution is not approved on the implementation. If this mechanism is introduced into the final act, South Africa will have, in our understanding, a more stringent remuneration governance than our developed counterparts. And we believe that it will be detrimental for business growth and economic recovery. Our view is that the one-strike approach is extremely onerous to a developing country like South Africa. If you look at a developed market like Australia, they've got a two-strike rule. So this will put us as one of the most onerous, or probably the most onerous jurisdiction in the world when it comes to remuneration governance. Honourable Chair, given the power afforded to shareholders of JSE-listed companies, as I mentioned earlier, to appoint all the directors on a rotational basis, all the non-executive directors, and bearing in mind that Remuneration Committee members are non-executive directors, the stand down after non-approval of a implementation report, in our view, is unnecessary for JSE-listed companies. We believe consideration should be given to codifying the regular rotation of non-executive directors in the primary legislation. I think the third point worth making, Honourable Chair, is that the stand down of Remuneration Committee members will introduce significant disruption, uncertainty, and risk to the ongoing governance of the company, which is critical in terms of operating and managing a business. We believe that the number of directors serving on boards will increase, which will significantly increase the cost of governance for, in our view, no discernible benefit when it comes to JSE-listed companies. We also believe that potential directors will have to very carefully consider the reputational damage that comes with a one strike and you're out type of proposal that is in the bill, and it may result in a shortage of skills, and we would potentially find it difficult to fill those remuneration committees with people with the right skill set. Honourable Chair, I think another challenge that we foresee is that the new committee members, once the existing Remuneration Committee members step down from that committee, there would be a new committee members that will be responsible for engaging with shareholders, and we believe it will become unmanageable and defeat the policy objectives contained in the bill. It's important that Remuneration Committees members have the right skill set to properly engage on remuneration matters and with investors who have concerns around this issue. Honourable Chair, I think the final point worth making on this slide is just the fact that the implementation report, in our view, is a retrospective account of the implementation of the remuneration policy. A non-binding vote doesn't change the outcome, and at best, it serves as providing the company with some sort of sentiment from shareholders on their view on remuneration. Next slide, please. Honourable Chair, we thought it may be useful to present the committee, and this is in our submission as well, with possible alternatives should it be decided to proceed with a binding vote on the implementation report. And I think if we proceed with that and it remains in the bill, we would recommend that the provision is made in the bill for a case where an ordinary resolution on the implementation report, where it's not passed, that the non-executive directors that serve on the Remuneration Committee must stand for re-election at the next annual general meeting. I think that aligns with what the safeguards that we have in place in the listing requirements, and it gives investors a more direct view and vote on those members that are charged with oversight of remuneration. We need to just be mindful of the fact that we need to provide an exemption in that case, and that's for committee members that have served less than 12 months in order to get some continuity on those committees. Honourable Chair, I think the alternative that we would suggest, if that is not palatable, is that we consider aligning ourselves with the two-strike model. As I said earlier, if we proceed with the bill in its current form, we will have the most stringent remuneration governance in the world. And as an alternative, and this is certainly a second alternative, is that we provide the opportunity for those committee members to stand down after 2 consecutive non-passing of the implementation report vote. Again, we just need to make provision for members that have served for less than 12 months in order to get the continuity going. Next slide, please. Honourable Chair, I think the final slide, we thought it would be useful to perhaps just deal with a very important principle, and that is one of shareholder engagement. I mentioned in my first slide the provisions that we've got in place, our so-called transparency and accountability framework on remuneration. That framework only works if we have active engagement from shareholders, number one, and if companies are armed with sufficient information to deal with the concerns of shareholders. So whether a binding vote is implemented or not, it is our view that it would be necessary to implement amendments to enable more effective shareholder engagement. We believe that is critical to the remuneration governance. It's certainly been our experience that JSE-listed companies often find it extremely difficult to identify the parties, those shareholders that have voted against the resolution, but also to engage with them and obtain proper reasons why they had concerns with the remuneration. So we believe that changes would be required to ensure more active engagement with shareholders. Honourable Chair, it's our view that a binding vote is only workable if there's a legislative or regulatory provision that compels shareholders, in particular financial institutions and proxy voters, to disclose their votes with reasons and then to engage with the company. Without this information, companies are at a huge disadvantage where they're unable to effectively engage with those shareholders and address their concerns. So again, irrespective of whether the vote on the remuneration policy and implementation report is binding or non-binding, we would recommend that the bill includes amendments that provide for an obligation for beneficial interest holders and proxy voters, certainly those that hold above a certain prescribed percentage and who voted against the resolution, to disclose their votes to the company and the reasons therefore in order to allow direct engagement and meaningful engagement. Honourable Chair, we also believe that in addition to the bill where there's a requirement for the Remuneration Committee to engage with dissenting shareholders is therefore critical. And perhaps the last point that we believe in order to ensure that we have proper checks and balances in place is to ensure that we include a provision that basically stipulates that where an implementation report vote is not passed by shareholders, and a certain percentage of those dissenting shareholders fail to engage with the company, that the resolution is basically reinstated in order to essentially allow shareholders or forcing shareholders to properly engage with the company, or as an alternative that the resolution then stands. Honourable Chair, I think I've utilised my 15 minutes. I will stop there and I will, together with my colleagues on the call, take any questions from the committee. Thank you very much.
Thank you. Can we ask Mr. Juden to please mute? Then please, portfolio committee members, there we have the presentation from the JSE done by Mr. Andre Visser. Can I take hands for interaction with this presentation? Honourable McPherson, we'll start with you.
Thank you very much, and thank you to the JSE for their presentation. I just want to ask that the gentleman expands on his statement that the bill defies the concept or the government status position on ease of doing business. How does he believe that translates into so? And also, what effect does he think that if it was passed in its current position, does he think that that would speed up the wave of delistings that have taken place? And then just some comment on what effect the remuneration clause would have on the process of remuneration. Would it actually hamper companies' abilities to fairly remunerate executives if there is this, idea or that people are only going to be able to serve for one term and then effectively be locked out for a number of years? And how would it actually discourage people from serving on the remuneration committee? Do you envisage a challenge then in attracting people to serve on these committees if the bill was passed in its current format? Thanks so much.
Thank you. Honorable Thring.
Thank you, Chair. Chair, with regards to the JSE being opposed to a binding vote on the implementation report, one of the reasons given was that this binding vote would increase the numbers of directors on the board and hence the cost to company or cost to governance. Can Andre please elaborate on how he sees that actually happening, where if the binding vote is implemented, how does that pan out to there being an increase in the numbers of directors? Is that new directors coming in? So just expand on that. And then secondly, with regards to shareholder engagement, is there any current teaching and training that the JSE engages in to provide shareholders with information that they actually need to hold companies accountable? Thank you, Chair.
Thank you very much. Honorable Mbuyane.
Thank you very much, Chair, for the opportunity. Chair, I just wanted a clarity from the presenter, JSE. They indicated that they fully support the policy on disclosure and also on SMS remuneration. But I'm not so sure in terms of their shareholding, 50%. And partially, my question has been asked by Honorable Thring. But yes, the non-executive disclosure that serve on a remuneration committee must stand off. And also, what is the policy uncertainty around those matters? Thank you very much, Chair.
Thank you, Honorable Mbuyane. Those are the questions thus far. Mr. Visser, over to you and your team.
Thank you, Honorable Chair. I will try to respond to the questions from the honorable members. Thank you very much for those questions. On the first question about the concerns that we've got about the ease of doing business, I think it fits in with a process that the JSE is currently busy with. I think members have raised the number of delistings that we've experienced on the JSE. And from a JSE perspective and as a listings authority, we've been very active in trying to make our listings framework as competitive as possible on the one hand. And secondly, to put measures in place to cut as much red tape as possible, but to still strike the right balance between the protection of investors, disclosure, and making sure that we remain competitive. So we've been very active in that regard. So we are fully supportive of any measures that will make it easier for companies doing business. The reason why we believe this would be contrary to that policy objective is that if remuneration committee members have to stand down from a committee and they were appointed for very specific reasons, for their very specific skill set, they would then still be on the board as directors, but they would not be able to be utilized for their very specific and unique skill set. It's our view that that would ultimately result in the board having to seek other directors that have that unique skill set. And over time, we believe it will increase cost and complicate the governance of the company. We believe that the safeguards that we've got in place, where shareholders have a direct say on who serves on the board of directors, including remuneration committee members, we think that's an appropriate balance and a fit for purpose approach to managing the interest of investors and the interest of companies and the interest of broader stakeholders. I think I've addressed the issue on delistings. We, as I said, we're having a critical look at our listings framework to make sure it remains fit for purpose. And we believe that the framework that we've got in place at the moment is a fit for purpose framework in terms of governance when it comes to remuneration, but more can be done in terms of engagement. The question from the honourable member on what disruption this would result in, again, it talks to the earlier point that it would potentially mean that these members who were put on the board for a very specific requirement, a very specific skill set, would no longer be able to execute that skill set for which they were put on the board. So we think that would result in disruption, and potentially companies would have to go and look for alternate directors with that skill set. The question from the honourable member on the increase in the number of directors and the step down, I think I've partially addressed that, but just again to re-emphasize, the remuneration committee members comes and are employed for the unique skill set that they bring to the table, and there's views both ways on that. But I think what is important is that a committee member a director that serves on the remuneration committee versus a director that serves on an audit committee or a social and ethics committee, specific and unique skill sets are required based on specific disciplines. And I think the same would apply for remuneration. So if remuneration committees have to step down from a committee immediately and they can no longer serve, it would potentially pose the question, where can that skill set be utilized? And you may see these guys stepping off the board and new members being appointed. And then the last question from the third question from the honourable member, I think I've spoken about that, about the standoff from the remuneration committee. We recognise that you can still serve on the board, but that comes with disruption, where a party is put there for a specific purpose. Thank you, Honourable Chair.
Thank you very much. We're doing well with time. Can I just check with Dr. Fourie if she has any concluding remarks?
Thank you, Honourable Chair. No concluding remarks. Just to say that we have the best interests of the country at play here, and the proposals which Andre has put forward really reflect one of a number of issues that we've raised in our submission. It's the most important issue, and we feel this issue will have a very material impact on the integrity of our markets, the competitiveness of our markets in the global sphere, and it has far-reaching implications. So thank you very much for your time, and thank you for giving us an opportunity to share our views.
Thank you. That's Dr. Fourie from the JSE. We are running slightly ahead of time. Committee Secretary, can we check whether the King Committee on Corporate Governance is ready to present? We are a few minutes early.
Chair, stakeholders has been asked that they be in attendance before the time, so they are available to proceed, Chair.
There we go. Thank you very much. And we hand over to the Chair, Ms. Ramahlo.
Thank you, Madam Chair. Thank you, honourable members, for your time this morning. We appreciate the opportunity. My name is Ansi Ramahlo. I'm the chair of the King Committee on Corporate Governance for South Africa, and I'm joined here this morning by my colleague, the Deputy Chair, Mr. Muhammad Adam. Just by means of context, I will give a short introduction to the King Committee and its work. The King Committee is run under the auspices of the IODSA, but we have autonomy and independence when it comes to the development of the content of the King Codes. The institutions represented on the King Committee include the Auditor General, SIPC, the Financial Sector Conduct Authority, IRBA, the JSE, National Treasury, SAICA, and others. Of course, our presentation today is the view of the King Committee collectively and not of any one of these institutions. Our task as the King Committee is the issuing of guiding practices for corporate governance. Now, these guiding practices give effect to the legal duties as per the Companies Act and are therefore rather important. For the most part, these guiding practices are voluntary, with the caveat that it's, as Mr. Visser has already explained, that the King 4 recommendations are incorporated in the JSE listings rules, and also our courts use King 4 as a reference point when determining whether directors acted in accordance with the standards of conduct as set out in the Companies Act. Before I get to our specific comments, I think it's important that I state as the King Committee that we are absolutely in favor of the reform efforts of the bill. We agree that measures that will enhance accountability and that will address inequality are necessary. I think where we have comments, it is rather about the way exactly in which it is proposed to be done. So the two aspects that we will focus on in our presentation will be the access to company records as per Section 26, and then the other issue, that of the vote on remuneration and the disclosure of the wage gap. Before I get to our specific comments, we do agree with the tabling of the remuneration policy for a shareholders' approval. We believe that it is constructive and in line with international leading practice. That's as far as the policy is concerned. I will deal with the implementation report in a minute. As to the disclosure of the wage gap, again, we agree that such disclosure is in the interest of enhancing accountability and in the interest of actions that could potentially perform to address inequality. Which brings me then to our specific recommendations and the comments that we want to raise on three issues. The first being the Section 26, which provides for access to company records. Our concern as far as this is concerned is that with the proposed amendments, our reading and interpretation of the amendment is that it will mean that any person, regardless of whether that person holds a beneficial interest or not, can access company records as stated, including the annual financial statements of a private company, a non-profit company, or a personal liability company that has above a particular PI score as outlined in the bill. We're not sure what the rationale of this proposal is and what its intended benefits may be, but it's a huge departure from the current position where private companies are by nature, some of the information is treated as being private. We think that this proposed amendment goes against the character of a private company and the purposes for which it is incorporated in this form. We also think that it may very well be inconsistent with privacy legislation. So our recommendation then is that access to company records in terms of Section 26 be limited to beneficial interest holders, and that it's made subject to the promotion of access to information and other privacy legislation. That's as far as our first comment is concerned. Our next comment is on the pay gap disclosure. As I've already stated, we would welcome such disclosure in the interest of accountability, in the interest of addressing inequality. Our recommendation just is with regards to the methodology for disclosure. We recommend that the disclosure should be required to align with the requirements of the Department of Employment and Labour by using the form EEA4. This form covers the disclosure of pay gaps for specific groups and level of employees, the specific groups that it addresses in addition to what is required in the proposed subsection is that of marginalized or previously disadvantaged employees in accordance with race, gender, and disability categories. We believe that using the form EEA4 has several benefits. The information is it's a more pragmatic approach in that it aligns existing legislative requirements, and also we believe that the format as per form EEA4 is more informative than the disclosure as proposed in the bill. Our comments really are, like the JSE's, focused on the voting on the remuneration implementation report. And here I will probably repeat much of what the JSE has said, but I will try and supplement it by giving a supplementary perspective. So we've already stated that we support the proposed vote on the remuneration policy, but not on the remuneration implementation report. The policy, of course, is the forward-looking document that stipulates the approach to be taken to remuneration and the principles that will be followed in the design and the setting of remuneration. The implementation report, in contrast, is where the company accounts for the outcomes of the implementation of the policy. In other words, how the policy translated in actual amounts being paid to the executive. It's an account of events that had already taken place. In this way, it's similar to the annual financial statements, and it's because the annual financial statements provide retrospective information that it's not subjected to a shareholder's vote, but simply presented at the AGM of a company in terms of the Companies Act. A binding vote on the remuneration report with the adverse consequences as provided for in the bill is not practiced in any other jurisdiction internationally, simply because it's ineffective to try and unscramble the remuneration egg. It's a fait accompli by the time that it gets to voting. The implementation report, in our view, should be presented at the AGM in the same way as the annual financial statements are presented, and in the same way as it's now proposed in the bill that the Social and Ethics Committee report be presented. If this course of action is followed, it doesn't mean that shareholders do not have recourse. Where shareholders are dissatisfied with the outcomes of the policy and or the discretionary actions taken by the board with regards to executive remuneration, they should ensure that the policy is amended to address concerns and to clarify the extent to which the board has a discretion in terms of the policy. So that is far as our comments are concerned on the actual voting of voting on the implementation report. And I've motivated now why we believe that the remuneration implementation report should not be subjected to a vote. In the next section, I will then deal, or in my next slides, I will deal with the consequences of the vote failing as a separate issue. When the vote fails, as we've heard this morning, it means that remuneration committee members must step down as committee members for a three-year period. They don't step down as board members, only as committee members, but as the JSE has explained, also we believe that it's still very disruptive. I can also just point out that the remuneration policy is tabled for approval every 3 years, or when significant amendments to it is made. By its nature, the remuneration implementation report will have to be voted on every single year. This means that a remuneration committee member who has not even been a member for a year on that committee could be compelled to step down if the voting on the implementation report does not pass. And that's just an example of one of the consequences. We believe that the stepping down consequence may prove detrimental to what the envisaged outcome of this amendment is. We understand the amendment to address accountability and oversight on executive remuneration. But we don't believe that this will be the case with this consequence of stepping down. Firstly, in instances where the remuneration committees need to step down after a failed vote, the directors with the best qualifications and experience for the job will no longer be eligible to serve on the remuneration committee. This means that the consequence in this situation is that a company will have its B team serving on the remuneration committee. It needs to be pointed out, as was done by the JSE, that executive remuneration is a specialist area and discipline. It's a scarce skill. The boards of bigger companies, where executive remuneration is actually the issue, profile and seek directors specifically to serve on the remuneration committee. That's why they invited to join the board. I mean, one of the concerns that are raised in relation to executive remuneration very often is the dependence on remuneration consultants. And the concern is that remuneration consultants may potentially be biased by the fact that their fees are paid by the very management on whose remuneration they are supposed to advise. And so independent remuneration committee members, the independent board members who serve on the remuneration committee, play a critical role in challenging the advice received from remuneration consultants. And we use this just as an example of the consequences that may follow from having the remuneration experts having to step down as a consequence of a failed vote. The second reason why we don't believe that these consequences will actually achieve the aim of the bill is because it will have a negative impact on the reputation of South Africa as an investor-friendly country. This there was a question about it, has been explained by the JSE. Because of its disruptive consequences, it's also not in line with the policy imperative of the bill, namely ease of business. The third adverse consequence, we believe, is of having this vote with its consequences on the implementation report, is that it will potentially disturb the balance of power between the board and shareholders. Shareholders could potentially hold the board hostage through a threat to vote down the implementation report if their various demands are not met. So, in conclusion, none of these potential consequences will not achieve the envisaged aim, in our view, of better oversight and accountability of executive remuneration, as the scarce expertise that can facilitate this, in other words, that can facilitate accountability and oversight, will be eroded. So our recommendations then is that ideally, our preferred option is that the remuneration implementation report be presented at the AGM in the same way as the annual financial statements are presented, and in the same way as it's proposed the Social and Ethics Committee presents its report to the company at the AGM. We do, however, we do think that the current dispensation, as provided for in the JSE listings rules and as provided for in King 4, namely that there's a non-binding vote, and that if the non-binding vote fails, that engagement is triggered, we believe that that is sufficient. We do, however, acknowledge that this engagement fails in some instances in the current dispensation because of sometimes apathy on the side of companies to reach out to shareholders who voted against the implementation report, and sometimes, on the other hand, because of shareholders not being forthcoming on the rationale for their decision to vote against the implementation report. So if it is then considered necessary to strengthen the current arrangement, we believe that it could be strengthened not by requiring the Remuneration Committee members to step down, but rather to enhance the quality of engagement between the company and shareholders. And that can be done, we believe, by compelling engagement by the company in the instances where the vote on the implementation report failed, if the legislator then decides to implement the vote, and further than compelling the company to engage, also then to compel shareholders who hold above, let's say, 3% of the shareholding to disclose the rationale for their voting against the implementation report. By including engagement as a mandatory legislative requirement, and also the process along which it will happen, and addressing the responsibilities of both parties to the engagement, there may potentially be a role for the legislator to step in. So, Madam Chair, thank you very much. That's in short the comments by the King Committee.
Thank you very much, Mr. Amalo. Members, I'll take hands for interaction with this presentation. Honorable Thring. Honorable Thring.
Thank you, Chair. Chair, South Africa, just one question, maybe two. South Africa currently has the largest stock exchange in Africa, and it is said about the 20th largest in the world. So the first question is, what is the comparative earning to Mrs. Ramalho? What is the comparative earnings of South African directors versus directors in other similar companies on other stock exchanges? Do we know whether our directors are overpaid, underpaid? Are we on par? So what are the statistics on that? And the second question is, how do we compare in terms of the discrepancy between the top 10% and the bottom 40%? Thank you, Chair.
It seems like there's no other questions to you. Oh, I see Honorable McPherson.
McPherson. Yeah.
Thanks so much. You know, I find it fascinating that the chair of the committee for the King Code effectively is rebuffing what the department said to us, that this is in line and to bring the bill within line within the King Code. Sorry, I shouldn't say the chair of the King Committee, the chair of the board of directors, and it is exact opposite actually of what the committee, well, no, not the committee, the department has told this committee. And I would just like some comment then on maybe from the chairperson of the board of directors, actually in your sort of guess how far removed this may be potentially from the King Code. Thanks so much.
Thank you very much, Honorable McPherson. Ms. Ramalho, over to you.
Madam Chair, thank you. Thank you for those questions. So I do believe that the earnings of our executive compared to that of the executive elsewhere, it's very difficult sometimes to make these comparisons because there's no direct comparison that can be made. It depends on buying capacity. Those things come into that comparison, and there may be some of my remuneration colleagues on the line, or even the deputy chair of the King Committee, who can also comment on that. But in general, I think it is comparable. In fact, that is sometimes what is used as a justification for the level of executive remuneration in South Africa, is to say that our members of the executive, and specifically CEOs, are the pool is an international pool, and therefore, as South Africans, we need to offer salaries that are competitive, not only in South Africa, but also internationally. Like I said, there may be somebody who could supplement this information on the call. As to the top 10% and the bottom 10%, I'm not aware of any statistics available, reliable statistics. The issue is that there is no disclosure on this at the moment, and therefore it is very difficult to compile these statistics. And so that is, of course, what the bill is attempting to address, and that is what we full-heartedly support. But as I explained in my presentation, we just think that there's a more meaningful way to do it, and a way that is more coherent with other pieces of legislation. So I just want to also then explain where, as the chair of the King Committee, when I say that some aspects of the bill are not aligned with international leading practice, I don't mean to say that none of it is. For example, the voting on the remuneration policy as opposed to the implementation report, that is very much in line with international requirements. In Australia, for example, there is the requirement for voting on remuneration outcomes, but in other words, similar to voting on the remuneration implementation report. But in that instance, as was also explained by the JSE, companies are allowed 2 strikes before the remuneration committee needs to step down. And that's a more reasonable approach because I mean, surely remuneration committee members, some of whom may not have been on the committee for even 1 year, should be allowed an opportunity to engage with shareholders to understand where the pressure points are, where the objections are, where they are misaligned, so that they can rectify it before they are required to step down. So we're not saying the bill is completely misaligned, but we're saying that there are aspects where the bill is misaligned and that there are reasons for that misalignment. As I've explained in my presentation, there's a reason why retrospective information is normally not subjected to a vote. It's because the remuneration has happened, the egg has been scrambled, as I said. Thank you, Madam Chair.
Thank you very much. Can I check with the Deputy Chair, Mr. Adam, or any of the team, if they want to add to the responses?
Thank you, Chair. I hope you can hear me and see me properly. I've just had a problem with my connection.
Yes, I see your
so on the remuneration.
Can I ask you to switch off your video? We've seen your face so that your network is a bit better. Okay, you may proceed.
Thank you, Chair. So, compiled locally. Chair, the other comment I just wanted to make is if you look at one of the cornerstones of the King Committee, it's about ethical and effective leadership in the context of social, economic, and environmental performance. And that is the heart of the King Committee. And in the King 4 report, you'll also see that the King Committee has highlighted the importance of responsible and fair remuneration practices. So insofar as that is concerned, there is alignment in terms of the principles we're trying to achieve. I think the point that we're making, and a number of speakers this morning, and in particular the point that Auntie is making, is that if we look at mechanisms to achieve better governance in the country or in general, we need to look at an institutional framework that is able to balance regulatory mechanisms, legislative mechanisms, and then effective leadership, which is voluntary mechanisms. The directors of companies have particular duties to run the companies in the best interest of the companies, and that must be allowed. If that balance is not right, what happens, Chair, is you then have the result of over-regulation or not getting that balance is dysfunctional behavior, and secondly, and more importantly, unintended consequences. So you could disrupt governance by having consequences like the stepping down rule in an environment where you're trying to get good directors, where you're trying to address issues around diversity, and to add this additional hurdle might not be beneficial. And there is also no proof really that this is beneficial and will lead to better remuneration practices. I think Ansi has mentioned, if you look internationally, there is no example anywhere in the world where there is a step down or a binding vote required for an implementation report or step down required in this regard. Thank you, Chair.
Thank you very much. Are there any, we have a bit of time, any concluding remarks, Ms. Ramahlo?
No, thank you, Chair. I'll stand by what I've said.
Thank you so much. We now move on to our next presentation, which is from the Institute of Directors of South Africa and the CEO, Prof. Nateson. I hope I'm correcting your surname correctly.
Good morning, Madam Chair and committee members. My name is Pami Nateson, the CEO of the Institute of Directors. And with me on the call today is Vikesh Nivandia, the executive in charge of policy and advocacy at the Institute of Directors. Just for very brief background, the IOD is a professional body for directors, having just under 9,000 members currently. And the IOD is also the owner of the King Reports on Corporate Governance for South Africa, and are big advocates for good corporate governance in South Africa. So we're here this morning together with the King Committee of South Africa, who just presented before us. And we, as the IODSA, fully support and are aligned to the comments and recommendations that have already been shared by Ansi Romalo and Mohammed Adam. As such, we'll not repeat these, but we'll briefly address in our presentation 2 additional areas for consideration by the Portfolio Committee relating specifically to directors. So in relation to the various amendments to the Companies Act, or the proposed amendments, we're generally supportive of changes being proposed to promote better transparency and accountability. And with regards to director skills, we're supportive of the proposed introduction of Clause 6A in Section 72 of the Act, which allows the minister to prescribe minimum qualification, skills, and requirements for the Social and Ethics Committee of the board. We feel that this clause is likely to elevate the authority and effectiveness of the committee, which we believe is critical in oversight of important matters such as social and environmental impact of business. And this addition, we also note, aligns to the already existing clause for the minister to be able to prescribe minimum qualifications and skills for audit committees. However, it needs to be noted that members of audit committees and social and ethics committees are usually selected from the full complement or pool of non-executive directors on the board. Therefore, we feel that the qualification, skills, and requirements for all directors needs attention and should possibly be covered by the Act. As our law currently stands, there's no minimum criteria that directors must meet in order to be considered for appointment to a board. So whilst there are some disqualification criteria, and they set out in Section 69(8) of the Companies Act, aside from these few disqualification criteria, almost anyone is eligible to be appointed as a director. And just for background, I'll just read them out. So as long as someone doesn't fall into one of the following, they're able to serve as a director. So a person is only disqualified if he or she, 1, is an unrehabilitated insolvent, 2, is prohibited in terms of public regulation to be a director of a company, 3, has been removed from an office of trust on the grounds of misconduct involving dishonesty, or 4, has been convicted in the Republic or elsewhere and imprisoned without the option of a fine or fine more than the prescribed amount for theft, fraud, forgery, perjury, etc. And we feel these few disqualification criteria, without having at least some minimum entry criteria for directors, is the bar is set far too low. We've addressed in our comment letter that testimony before the Zondo Commission demonstrated how important a role directors play in creating and maintaining well-governed and sustainable organizations, and how dire the consequences are if they don't appropriately just discharge this critical responsibility. It's quite clear to us that oftentimes the failure of boards and the individuals on them in both the private and public sectors to understand their governance role, to fulfill their legal duties adequately, the lack of ethical leadership and a lack of governance or directorship competence often lies at the heart of many of the challenges that our corporations in South Africa are facing, and hence our country is facing. like any other profession, serving effectively as a director requires its own unique, both functional and technical competencies, as well as social and personal competencies. And we believe directorship should be seen in its own right as a profession. And as such, directors should even be required to hold a professional designation in order to serve on a board, which would ensure that they at least meet a minimum required standard, not only of knowledge and experience, but also of conduct. And I think this concept aligns closely to the national framework towards professionalization of the public sector. The Companies Act could therefore be strengthened, I think, by stipulating required competency or minimum criteria in order to be appointed as a director, especially for listed companies and SOEs, with their impact being so wide and extensive in these areas, aside from the introduction of the clause around social and ethics committees and the current clause around audit committees, where the minimum requirements can be prescribed by the minister. I think related to director competency is also director accountability. So in order to hold directors to account for fulfilling their legal duties, the Companies Act provides already a very valuable remedy for director delinquency. And we fully support and commend the extension in this bill of the time frame in which such an application for delinquency can be brought. Having said that, we feel that this remedy is not often used by companies as often as it should be, possibly due to cost, effort, and time that it takes to bring such an application to court. The one director delinquency case that we did see successful in recent times was brought about by a civil society organization, not by the corporate on which the individual was serving. So unfortunately, what we see is that directors who are guilty of misconduct are sometimes simply removed from one board, but then continue to serve on other boards. And as a result, this misconduct continues to be perpetuated in the system. So consideration could also therefore be given to requiring some sort of statutory or regulatory body for directors, similar to other professions like chartered accountants, lawyers, and even doctors, who all have to maintain a certain professional designation in order to continue practicing. Naturally, as with any profession, membership of a professional body does not necessarily guarantee competence or good behavior for that matter. However, what it does do is ensure that at least there's some minimum entry criteria of basic knowledge, skills, and track record that are met before an individual is accepted. It also ensures that knowledge is required to be kept up to date through continued professional development. It ensures that the professionals who belong to a body of this nature have to abide by a professional code of conduct in order to retain their good standing. And most importantly, individuals of these types of bodies can be disciplined for infringing the codes of conduct and thus have their license to practice removed, ultimately protecting, I think, the public interest. So whilst the removal of a director's license to practice by a professional body would still require fair and due process aligned to the provisions of natural justice, it could certainly offer a less costly and time-consuming mechanism than the current court process for delinquency. So with that, we feel the Companies Act could be strengthened in terms of accountability for directors by enforcing some sort of license to operate through a regulatory body, especially in order to serve on our listed companies and SOEs. And we believe this could go a long way to improving the performance of boards by holding directors accountable for their conduct and ultimately protecting the public interest. Thank you, Chair. That's all from me.
Thank you very much, Prof. Natterson. PC members, there we have the presentation from Institute of Directors of South Africa. I'll take hands for interaction with the presentation. It seems like you are fairly covered. Members, last take. Honorable Thrim.
Chair, no, I think very simply, I want to support the comments and recommendations by Mrs. Nattison on holding directors accountable. I think that if we have some of these kinds of provisions in terms of having a professional set of guidelines for directors like you would have for doctors and other professions, we would not have, or we may have at least reduced some of the collateral damage that we've seen from the failure of certain directors, like with Steinhoff and currently or recently Tongaat Hulett. So I think very clearly there needs to be a tightening up, and we cannot, I think it's inconceivable that we would have directors failing in one company or on one board and then are just moved to another board. And where we seek to hold directors within the public sector accountable, I think similarly we need to be looking at holding directors in the private sector accountable, particularly where huge amounts of investment, some of your public's pension, their life savings goes into these particular companies, and where we have delinquent directors, we cannot have them causing damage and, in a sense, destroying the lives of the public. So in essence, I am agreeing with the comments made in the presentation by the Institute of Directors in South Africa. Thank you, Chair.
Thank you very much. Honorable Hloniana.
No, thank you very much, Chair. We welcome the presentations, very informative as well. I don't have much to say. I just wanted to ask one question to the presenters that with the presentation that they've done, especially as they spoke about how a director will just be moved from one area to another area, and they don't get to account, or they don't get to be arrested. What exactly do they think that we must do to make sure that this thing of just a person messing up in this department and then just getting moved to another one, what exactly do they think that we need to do to make sure that this scourge ends? Thank you very much, Chair.
Thank you very much. I think the two questions are related. Prof. Nattison.
Thank you, Chair. Yes, I certainly agree that we definitely need to see more accountability for directors, and we need to see more consequences. This issue of consequence management comes up often in IOD events and training, etc., where people just feel that there's just not enough consequences for behavior out there. So as I explained in my presentation, is there are mechanisms to hold directors accountable, and currently the delinquency provision in the Companies Act exists. But having said that, we don't feel that we see enough of these. We have a sense of misconduct out there in general, wider than the number of delinquency cases that we see coming through our court system. And our feeling or our perception is that it's because the court system is lengthy, complex, costly to be able to bring these sorts of applications. We're currently working on a guidance note on director delinquency to try and encourage corporates to be doing more of this, so holding their own directors to account and actually taking these cases through. But having said that, I think my second point around having some sort of license to operate for directors is even more critical. You know, often with a lot of these corporate failures that we've seen both in the private and public sector, you would have seen the public, there's an expectation, for example, on a body like SAICA to take disciplinary action against members and remove the chartered accountancy designation from these members if they are found to have breached the code and acted contrary to the best interests of their organizations and the public's interest. And we believe such a mechanism is necessary for directors as well, in order for bodies to have more teeth in holding directors accountable. So just from our perspective, just to add that oftentimes when there are these corporate collapses or accusations against directors, us as the Institute of Directors being a voluntary body, we often, when we check the names of individuals, find that they are not our members, and therefore we can't take disciplinary action against them with us being a voluntary body. So I think if there was some sort of enforcement of directors belonging to some sort of statutory body that oversees them, I think it would go a long way to us being able to hold people accountable and remove their licenses to operate where necessary. Thank you, Chair.
If I may just ask a follow-up question, is there precedents elsewhere in the world for licensing of directors?
Sure. So my colleague Vikeshni may want to come in on some of her knowledge in the global space. But what we understand from our interactions on the Global Network of Director Institutes is there may not be requirements in the legislation. However, there are market forces that sort of push that directors do belong to Institute of Directors or similar bodies internationally. I think, Vikeshni, if you do have any more information on that.
Thank you, Pami. No, globally, I think there's been a lot of debate as to whether or not there should be a need to create this license to operate or make it statutory to have a professional designation. Some of that also, I think, happened in Australia due to some of the corporate failures, but nothing's actually been done from a legislative perspective. I think a lot of our International Institute of Directors, however, do have a greater presence of actual directors being members. So I think that also helps the cause of holding accountability compared to in SA. But there is definitely, I think, talk about it, and I think given our current South Africa context, there may be definitely a need to put that into legislation.
Any concluding remarks, Prof. Mattison?
No, Chair, thank you so much for the opportunity, and we make ourselves available to work with the department if necessary on some of these things. Thank you.
Thank you very much. Members, we now will break for 10 minutes for tea, and then we'll I think we'll reconvene at 10:05. Thank you very much. Sorry, 11:05. Thank you so much.
Recording stopped.
Thank you, members. I hope you enjoyed your cup of tea. We will resume with
Recording in progress.
the public hearing on the companies amendment bills. We'll now take the presentation from the Law Society of South Africa, and that's Ms. Masipa. Over to you.
Good morning, Madam Chair. Good morning, colleagues. My name is Eunice Masipa from the Law Society of South Africa. I'm the president, and I'm just going to give you a quick 3 minutes summary of who we are as the LSSA. I'm trying to share my screen, but I see the host has disabled participants from sharing screen, Madam Chair. Will that be sorted, or can I just proceed?
No, let's wait for the committee secretary to sort that out.
Okay, thank you.
Committee secretary, can we enable Ms. Masipa to share a presentation, please?
It's done, Chair.
Okay. All right, let me just try again. It says host, disable participant screen sharing. I'm still unable to share the screen, Madam Chair. Okay, there we go. There we go.
Okay, thank you.
Right.
Apologies for that. Please proceed.
Not a problem, Madam Chair. Let me just go into slideshow mode. As I said, Madam Chair, we just want to give a brief introduction of who we are as the LSSA. So basically, the Law Society of South Africa brings together the Black Lawyers Association, the National Association of Democratic Lawyers, and the Independent Lawyers Association. We are a voluntary association which was created by a constitution in 1998. However, in 2018, we amended our constitution where we extended our mandate to include all 9 provinces in terms of forming provincial associations. And I think, Madam Chair, what is important to note about the LSSA is that when the Legal Practice Act came into action, the LPC did not replace the Law Society of South Africa. We continue to exist as an independent voluntary body, a members' interest organization, and the LPC remains the regulatory of the legal profession. What the LSSA does, we uphold and we safeguard and advance the rule of law and the administration of justice. We also seek to initiate, consider, promote, support, oppose, or endeavor to promote and strengthen legislation, whether existing or proposed, reforms or changes in law, practice, procedure, and the administration of justice. We also strive towards the achievement of a system of law that is fair, just, equitable, certain, free from unfair discrimination. And Madam Chair, the LSSA is comprised of various departments, one of them which is professional affairs. And in that department, we've got 32 specialist committees, which comprise of practicing attorneys who are experts in their field of law. And those committees include committees focusing on ADR, constitutional affairs and human rights, court practice, criminal law, company law, ethics and rules, amongst others. Now, the primary focus of professional affairs, Madam Chair, is advocacy through stakeholder engagement, which includes government departments, quasi-government structures, and the judiciary, also other organizations. We also have LEAD, which is legal education and development, where we offer post-admission training programs to practicing legal practitioners to keep abreast of developments in the profession and ensure that the professional standards of practice are maintained and enhanced. We also have Derebus, which is our digital magazine, which is available free of charge to all legal practitioners, which is ordinarily used for research and reference purposes, amongst others. And as I conclude, Madam Chair, before I hand over to the Deputy Chair of the Companies Law Committee, who will go through our submissions, the LSSA also makes written and oral submissions on issues that affect the administration of justice and the rule of law, including to Parliament. We litigate in public and or professional interest cases. We also provide resources to assist and provide general guidance to practitioners to provide the highest quality of legal services to the public. We also facilitate membership programs for attorneys and candidate attorneys. And important to note, we also have an international, regional, and national recognition. Madam Chair, I'm now going to hand over to Abigail Reynolds, who is the Deputy Chair of our Company Law Committee, who will go through our submissions. Thank you, Madam Chair.
Thank you, Mr. Reynolds.
Good morning, Madam Chair and the committee. Thank you so much, Eunice. My name is Abigail Reynolds. I'm the Deputy Chair of the Company Law Committee, and I'd just like to put forward a very summarized version of the submissions we made. Can you see that screen nicely?
No, we don't see anything on the screen. Okay. Can we just sort that out first?
Sure, let's do that. Thank you.
So who's sharing the presentation?
I am, Madam Chair.
Sharing your own? Oh, okay.
Thank you. Okay. Thank you.
Okay, we don't have it yet.
Oh, I'm so sorry. I can't know why.
Committee Secretary, can we just check why we can't see the presentation?
Chair, she has been given co-hosting rights. She should be able to, but let's just check if we can't share it in the meantime. Quickly check. There we go.
Can you now see the presentation, Madam Chair?
Yes, but just go into slide mode.
That's when I lost you before, so I'm hoping not to again.
Okay, we're not fully in slide mode yet. We just want to see one slide at a time on the screen.
Chair, I think she needs to swap displays.
Okay, there you go. Thank you. Has that yet worked?
Yes, great. Thank you.
I apologize for wasting any time.
No, not a problem.
All right, thank you, Madam Chair. So we submitted the comprehensive written submissions, but this is just a summary. They're obviously quite technical, us having focused on the interpretation and meaning of the proposed amendments in the exact wording. Just to run through them briefly, this is our only comment on the second amendment bill, bill number 26. We just, whilst we support the amendment completely, we found the clause to be slightly ambiguous, and so wanted to recommend that it is amended to clarify its intended purpose. Specifically, I've recorded there that we thought the two subsections 2A and then 2 capital A subsection A should not refer to each other, but also that the wording, whether or not such circumstances occurred before the extended period, we found confusing and must be simplified. So we didn't actually propose the exact final wording, but that was our submission in regard to this bill. Thank you. Then now moving on to the more lengthy Companies Amendment Bill number 27. The definition of securities in Section 1 of the Companies Act includes and introduces the word debentures. Our comment is that the word debentures should be defined for the sake of clarity as it is not defined in the Companies Act. And in that regard, we recommend with regard to Section 43, subsection 1A, that the definition of debt instrument is replaced with the definition of debentures there, so that it also speaks to this definition of securities in Section 1. And we have proposed wording for the definition of debentures that we would recommend, which is a written acknowledgement of debt issued by a company for one or more loans made to the company, whether on a secured or unsecured basis, which acknowledgement designates the debts as debentures and specifies the terms applicable, including that the debenture is or are freely tradable, but does not include promissory notes and loans, whether constituting an encumbrance on the assets of the company or not. Regarding the proposed amendments to Section 26, Our proposal there regarding subsection 2 is that the proposal that a person not contemplated in subsection 1 of this section 26 may also inspect and copy the information is inconsistent with section 31. Section 31 being entitled Access to Financial Statements or Related Information. So section 31 provides access to financial statements or related information under very limited circumstances only. For example, granting a judgment creditor or trade unions access to financial statements under certain conditions. We propose that section 26 subsection 2 should also then be made subject to the provisions of section 212 of the Companies Act, which is entitled Confidential Information. Regarding the insertion of the new section 30 capital A, these are our proposals. The proposed subsection 30 capital A1 should deal only with the initial remuneration policy, and our proposed wording is that it read, a public company or state-owned company must prepare a remuneration policy for directors and prescribed officers in the first 12 months of this section coming into effect, and present such policy for approval by ordinary resolution at the first annual general meeting after the policy is prepared. Then subsection 2, we would then propose be amended as follows, dealing with the policy after that initial one has been approved. The remuneration policy, once approved as contemplated in subsection 1, must be presented every 3 years for approval by ordinary resolution at the annual general meeting within that 3-year period. In addition, an approved remuneration policy must be presented for approval by ordinary resolution if any material change in the policy is proposed to be introduced during that 3-year period. If our proposals to the subsection 1 and 2 that I've just read out are accepted, then in subsection 3B, the reference to subsection 1 must be deleted because it would only then deal with the initial policy. In subsection 3C of this new section 30 capital A, our proposal is the word implementation should read remuneration. You'll see that that is our comment throughout this section. And the subsection 4A should be deleted as it is a matter of internal policy of how the report gets prepared. It refers to the board approval of the report, the subsection 4A. We recommend that subsection 4C then gets deleted. In addition to subsection 5, subsection 5's deletion being because voting on the report cannot constitute voting on the policy, which is what it refers to. In regard to subsection 7, our comment is that it is unclear and should be redrafted. We have proposed the following wording. Until a new remuneration policy is approved, the previous policy approved in terms of section 30 capital A or a policy approved by way of non-binding vote from shareholders under the King IV Code before section 30A came into force will be applicable. If there is neither an approved policy under section 30 capital A nor a policy approved by non-binding vote, the policy will be deemed to be the remuneration paid to the directors and prescribed officers before the new remuneration policy is approved. In regards to subsection 8 of the section 30 capital A, the words by ordinary resolution in terms of subsection 7 would then need to be deleted. And finally, in respect of subsection 9 of the section 30 capital A, our overarching question is that, is the subsection not meant to deal with the policy and not the report? And that it should be made obligatory in instances where there is no remuneration policy approved in terms of section 30 capital A to present a remuneration policy at every annual general meeting until same is approved. Thereafter, it can be presented for approval every 3 years or whenever any material change in the policy is made. It's suggested that a subsection C be inserted in this regard. We also refer you to our comment on subsection 7, which I already read out. For the entire remuneration committee to step down may lead to unintended consequences, including loss of institutional memory. Our recommendation is that it should rather be that 1/2 of the non-executive directors be replaced by other non-executive directors to ensure some continuity. We comment again that the word implementation in that subsection 9 should be replaced with the word remuneration wherever it appears in this subsection. And that subsection 9B refers to non-executive directors the Companies Act does not define the concept of non-executive directors, so perhaps this is unclear or should be defined. I move on to the proposed amendments to Section 40 of the Companies Act. Our comment is that the word trusted in Section 46, capital A, this definition of stakeholder is subjective and should be deleted, and the wording be amended for the sake of clarity. With regards to Section 45's proposed amendments, our comment is that the clause B regarding the new subsection 2, capital A, does not go far enough. It should cover financial assistance to any group companies. We have proposed an amendment as follows for the new subsection 2, capital A. The provisions of this section shall not apply to the giving by a company of financial assistance to or for the benefit of, and then not to refer only to its subsidiaries, but to carry on as follows. A, any company in a group of companies of which it is a holding company. B, its ultimate holding company or any intermediate holding company, subject to the common law that the board is satisfied that there is a reasonable benefit to the company in giving such financial assistance. And C, any company forming part of the same group of companies as it is a member of. Moving to Section 48, which deals with repurchases of a company's shares, the LSSA is of a view that a pro rata offer that is made pursuant to subsection 8B1, if there is a pro rata offer that is made pursuant to subsection 8B1, there should be no need to get a shareholders' resolution for the directors, since they are participating on a pro rata basis. We therefore believe there should be a carve out in this regard. We recommend that provision should be made for the acquisition of shares from a wholly owned subsidiary. The proposed subsection H should not apply if shares are being acquired, but no consideration is made by the company. And in addition, no mandatory offer as contemplated under Section 123 is triggered by the acquisition of shares as contemplated in subsection 8B1. We recommend that a new subsection should be added as follows. Unless an acquisition by the company of its securities is being done pursuant to Section 114, none of the provisions of Section 114 apply. 114 obviously being respective schemes of arrangement. Regarding the proposed amendments to Section 72, we have proposed wording for Section 7, capital A, subsection B, as follows. 7, capital A. The Social and Ethics Committee of a company must comprise not less than 3 members, provided that, in the case of a public company and state-owned company, all the members must be directors who are not involved in the day-to-day management of the business of the company and must not have been so involved at any time during the previous 3 financial years. And in the case of any other company, not being a public company or state-owned company, the members must consist of not less than 3 directors or prescribed officers, at least one of whom must be a director who is not involved in the day-to-day management of the business of the company and must not have been so involved within the previous 3 financial years. And finally, with regard to the amendments to Section 118, we propose that the meaning of indirect shareholders is not clear and should be changed to the wording holders with a beneficial interest. We also submit that the number 10 is a very low threshold and should be increased to 20. Thank you very much, Madam Chair and the committee.
Does that conclude your presentation as the South African Law Society, the Law Society of South Africa, sorry?
Yes, thank you so much. It concludes our presentation.
Thank you so much. Portfolio committee members, may I take hands for interaction with that presentation? Honorable Thring, I see you have unmuted.
Unmuted before I raise my hand, Chair.
Yeah, no, that's fine. Proceed.
Chair, thank you. Just one question to the Law Society. Do you have any concern that, I think it is Section 26, one of the sections which is the requirement for private companies to disclose detailed remuneration. Do you have any concern that this kind of disclosure may inadvertently lead to improper takeovers, violent takeovers by competitors, and in the process possibly creating monopolies. Thank you, Chair.
Thank you very much. Any further interactions with this presentation? It seems not. Back to you, Ms. Reynolds.
Thank you, Madam Chair. That's a very interesting question, and it might be one for the Competition Law Committee to consider in respect of your comment about creating monopolies, etc. But we are generally concerned about the length of disclosure of information and wanting it to be only really in as much as is required to achieve the intended goals. I don't believe that we have discussed it from the angle that you propose, which is, so I do find it very interesting. But yes, I imagine in the realm of takeovers that it would add arsenal to the company in terms of information that it might need to enforce an effective takeover. But I'm afraid we haven't discussed it at length, but I will take it back to the committee. Thank you.
Thank you very much. Can I just check with President Masipa if she has any concluding remarks?
No concluding remarks from my side, Madam Chair. I believe Abigail has covered our presentation. Thank you for the opportunity.
Thank you very much. So as a committee, we move on to our next presenter, which is the Independent Regulatory Board for Auditors. And Mr. Vanker, over to you.
Chairman, thank you very much and good morning to you. I am joined by my colleague, Sadia Adam, who will drive the slides. It's a real pleasure to be here with you, and I would like to just offer a word of congratulations on the exemplary arrangements for today's meeting. There's just been fantastic communication from the Secretariat, which has made preparation for today very easy for us. So I really appreciate that. Chairman and honorable members, my name is Imran Vanker. I am the Standards Director at the IRBA. The IRBA is a statutory regulator of the audit profession. In other words, we give the auditors the license to audit in South Africa and set the standards for them. As a result, the matter before you today is extremely relevant to our work. Companies will do the preparation, auditors will be asked to check what has been prepared. And so therefore we took an interest in both commenting on the bills and also being here to share with the respected and honorable committee members some of our thoughts. We have a very short presentation. We're only going to raise 3 or 4 issues with you. But what I'd like to mention is that the audit profession in South Africa is made up of about 4,000 registered auditors. And these 4,000 people are the ones who provide all of the assurance that supports the reporting ecosystem in the country, a very key ingredient in the work that the CIPC does. And therefore, we're very supportive in general of what the bills put forward. So as we reflect in our very first slide, we have a few overall comments to make. The first is that we think in general, what is being proposed, Honorable Chairperson, is going to help strengthen the ecosystem. And so we're mindful that all of the responsibilities should not land up on auditors. And as speakers before me have said, responsibilities need to be shared elsewhere, including responsibilities for directors. And we think that many of the provisions being put forward really are supportive of that vision. I think the second thing that these provisions do is that they help restore confidence in the integrity of reporting in South Africa. This is a journey. We continue to make investments, and the work that both the CIPC and your committee are doing are supportive of that overall goal. So really grateful for that. That said, there are a few specifics that we'd like to delve into a little bit deeper, and that relates to these topics. The first is the question of a remuneration report. And we use this word in introducing it. This word is called the auditability of a report. Now, we recognize and acknowledge the need for the remuneration report. The question that arises, Should the remuneration report be audited, and can it be audited? We argue, because of our specialist experience in the area, that the report probably can't be audited because there is not a standard set of criteria against which it can be audited. By that I mean, everyone's tastes may differ, people may provide different kinds of information relevant to their institution. And like the draft currently excludes other parts of the proposals from audit, we think that consideration should be given to exclude the audit requirement of this report. And we have provided 3 options in our submission to allow to recognize that there may be different ways that this can be solved, but also understanding that this is a challenge that we have currently in our Act in relation to the Company Secretary's report, the Audit Committee report, and the Director's report. And so we're making a proposal, Honorable Chairman, that this may be an opportunity as you work through the comments that you have received, and you'll see a similar comment in the reports of the member body, in the letter of the member body, for us to make these amendments transversely in order to fix this auditability question. We highlight also that there may be an error that has crept into the proposal in section 34A, where we think that the implementation report was also meant to be or intended to be not audited. And maybe that needs to be, maybe the committee would want to consider that as you reflect on all of the submissions that you have. Chairperson, we start with this because we think that as you make a decision and the Assembly votes on the implementation of the remuneration report, we do not want to stumble in the implementation of it in the marketplace with questions from auditors about how it should be audited. And for this reason, we're making the proposals that we make here, including the proposal explicitly that the committee may want to consider excluding the requirement to audit these reports in the relevant sections of the proposals. Moving on to the next section. So I'd like to offer a scenario here to illustrate the point that we're making. So by way of background, MAFR stands for Mandatory Audit Firm Rotation. This is a proposal that the IRBA has been championing for a number of years. And what it involves is that we believe that audit firms should not have long relationships with their audit clients. We think that it is unhealthy. It may lead to threats to independence. If my firm is the auditor of a client for 20 years, 30 years, 40 years, and beyond. The IRBA a few years ago introduced a rule that said you must rotate your auditors within 10 years and nothing longer than that. And alongside that rule, we needed some changes to be made to the Companies Act to support the MAFR rule. And so the bill proposes to make these changes, and it makes a very important change. It makes a change to reduce the cooling off period for someone who was previously doing work for the firm to say, cool down for 2 years before you can become the auditor, whereas previously you had to cool down for all of 5 years before you became the auditor. We think that this is extremely helpful. It will be beneficial to all the players in the market. It will create opportunities for people to get work, but also it will improve the eligibility of firms in order to support the implementation of MAFR. Of course, committee members may be interested to hear what has become of mandatory audit firm rotation. We know from the statistics that over 90% now of JSE listed companies have changed their auditors before the 1st of April this year. So that has just been a fantastic acceptance of the rule that we had enacted. Unfortunately, during the course of this year, the rule was struck down by the Supreme Court of Appeal on procedural grounds. And so the IRBA is looking to, alongside working with Treasury, to find a legislative solution to reenact the MAFR rule. The good news for honorable committee members and chairman, is that the proposals before us today are consistent with our thinking around MAFR. The IRBA is wholly supportive of this. And I think in general, we'll hear that the industry and profession and people involved in this will be comfortable with it also. Before we move on to the next slide, let us make this point. The importance of the cooling off period that you are proposing is that it will prevent auditors from marking their own tests, prevent them from marking their own homework. And I think that's a logical proposal that can easily be supported. You shouldn't be doing the homework and marking your own work. That doesn't breed confidence in the people who are going to see the scores. And they're going to say, oh, no, you may have a conflict of interest here. So that's a very important thing. And also, crucially, the way it is set up in your proposal, you apply it at the firm level, not to the individual engagement partner. And we also think that is excellent to ease implementation in the market. Chairman, however, as you have dealt with, or as the CIPC has dealt with proposals in respect of Section 92B5 on MAFR, we think that there's an opportunity that really ought not to be missed while you're considering public comments on this proposal, and relates to two sister subsections that sit alongside Section 5. It's Section 2 and Section 4. One of them is just a logical change that has to happen, because if you've reduced the overall period from 5 years to 2 years, then having another section, a few paragraphs up that says for more than 1 year will just cause unnecessary confusion in the market. What is more than 1 year and what is less than 2 years? And so we're recommending, and we've provided language to this effect, that in subsection 2, we really would encourage the committee to respectfully consider the deletion of the words for more than 1 year. And also in subsection 4, we would respectfully ask the committee to please consider deleting the words habitually and regularly. When the Act was introduced years ago, these were probably put in place to provide some relief to the market, so that practitioners could have some wiggle room to do some work and to continue doing it before they become the auditor. But the marketplace has changed substantially in the years since the Act was originally implemented. And our view now is that there's just such an abundance of service providers in the market that can provide the services specifically described in subsection 2 and subsection 4. And therefore, we say that the relief that the legislature had considered is probably now superfluous. It isn't needed anymore. And therefore, as you propose to drop the cooling off period from 5 years to 2 years, we would encourage you as the regulator of the audit profession to also make these two small changes in subsection 2 and subsection 4. Chairman and honorable members, I'm moving on to the very last of the messages from the IRBA. And this relates to the question of the public interest score. Allow me to cycle back here and say that the public interest score was one of the innovations of the Companies Act. It really at the time provided an incredible amount of interest, but an important amount of relief to small businesses. It said to a small business, if you are really small, then one of the reliefs offered by the Companies Act to you is that you won't have to be audited. There are other ways in which you can prepare your financial statements. We said to them, we think that audit is a really big challenge to you as an SME. Let's give you some relief from it. And the innovation that the Companies Act created at the time was that it said, let's try to determine how much of public interest there is in your business. And let's give it a score. And if that score is over 350, then let us say and agree that the public should have an interest in your business, and therefore you should be audited. There should be no escape for you. Now, Honorable Chairman, that score of 350 was determined all the way back in 2011, 13 years ago, and that score hasn't changed for 13 years. And so one of our encouragements, and really taking the opportunity of appearing before your committee to give this testimony, is to say that as the committee and the department reflects on what could be changed, we think that this is an opportunity, a low-hanging fruit to make a really big impact on the life of businesses. And why do we say this? Honorable Chairman, in 2011, the price of a litre of fuel was 10 Rand. Today, the price of a litre of fuel is 25 Rand. So a service station was selling fuel at 10 Rand back then, who was not considered to be a public, not considered to have a public interest score of 350. Now, simply because of inflation, that exact service station now must have an audit and must have all of the regulatory burden that comes with it. And we don't think that that was necessarily the intention of the legislature or the CIPC at the time, and certainly wasn't the spirit in which we all participated in determining the public interest score. The examples are endless. A loaf of bread in 2011 was 7 Rand a loaf. We know what the price of a loaf of bread is today. As those prices have changed, this crucial score has remained unchanged. And so we would encourage, please, and respectfully, a reconsideration of this matter. You will find alongside our submission, there is a similar submission with a great deal of detail provided by the South African Institute of Chartered Accountants, representing its 50,000 plus members, making the same case. And so this is one of those unusual circumstances, Honorable Chairman, where the regulator of the audit profession, the member body, small businesses, audit firms are unanimous in their view that this is something that consideration should be given to increasing the score. And the IRBA is open to whatever level a new score could be. We think it could be increased to at least 700 points, doubling what it was. But we will also be supportive of a higher PI score, depending on the insights that you bring to this discussion. Let me say this, that there can be a substantial cost difference between a company being audited and one not being audited. And it is a very easy way and effective way for Parliament, through your committee, to show and demonstrate how some hurdles to operating for small businesses are being removed merely by updating the score. The actual scoring sits within Regulation 26 and 28, but I believe through the combined cooperative work between all of us, the work that the committee does, and of course the work that the department, CIPC do, together we'll be able to make some progress on this point. Chairperson, then to recap, because this was the last of the points we were making, the IRBA is very supportive of the work that is being done and the proposals being made. We think that they together help strengthen the reporting ecosystem in South Africa, help to engender confidence. We hope that you would consider one of our 3 proposals, please, in respect of the auditability of the remuneration report. We think it will remove obstacles and help to smooth the passage of the remuneration report so that we'll see these disclosures quickly in the marketplace. We are supportive of the cooling off period change from 5 years to 2 years, but at the same time ask respectfully of the committee to also consider some other deletions sitting in subsection 2 and 4. And then finally, we're reflecting on the PI score and respectfully requesting the committee to reconsider the level at which the PI score is set and to consider a higher score. Thank you for the opportunity given to make this presentation. I will really value this. It's a wonderful opportunity that you've given to the public to be heard, and we'll have confidence in the process that what will come out of it will be of benefit. And of course, as a regulator, we will support through our inspection work the implementation of whatever it is that the House eventually adopts. I remain at your disposal, Chairperson. Thank you.
Thank you very much, Mr. Banker. Portfolio committee members, can we have a show of hands for interaction with this presentation? Honorable Thring.
Chair, thank you. Just maybe 2 questions. You're recommending that, Mr. Banker, that the remuneration report should not be audited. what are the consequences that auditors would face if the remuneration report is audited or is bound by the bill to be audited? And then secondly, the public interest score, which you recommend should be increased from 350 to 700 points. Could you elaborate on what are the criteria that is used to determine the points for the public interest score? Thank you, Chair.
Thank you very much. Honorable Monakedi.
Thank you very much, Chair, and thanks for the presentation, very clear, with very reasonable recommendations, which obviously still have to go through our committee at the later stage. But my question relates to the same issue that Honorable Frank has raised around the remuneration report, whether it should be audited. And the recommendation is that it should not be audited because there are no standards or there's no framework. So I want to check, are they not therefore proposing that those standards or that framework should actually be put in place so that going forward it should be audited? So I just want to check whether are they not also making that proposal going forward. Thank you very much.
Thank you. Mr. Vanker, I don't see any further hands. Over to you for responses. Thank you.
Honorable Chairman, thank you to the honorable members for the questions. What would be the consequences if we asked auditors to audit this? It's likely that they will come back to us to say that we are unable to do this. And in our audit report, we're going to exclude an opinion of it. We're going to say that this is unaudited. We've read it, but there's nothing more we can say about it. And so the market is going to get no assurance from it. They're not going to get a sense that this is any good or bad because they've not been able to check it. The challenge is that there is no framework and there's no institution in South Africa who has the responsibility to prescribe a framework. So let's delve a little bit into it. For example, what level of detail should be in the remuneration report? Should be 1 page long or 7 pages long? What level of disclosure of policies should be in there? Those things right now could be, as long or as short as you'd like it to be. What we expect could happen in the medium to long term, honorable members who both asked this question, is that as some practice develops over this, then it is likely that some standardization could emerge. When standardization emerges, then it would lend itself to standard setting, and then it could lend itself to auditing of it. So we think that that's probably a phased and logical, a phased way in which it could happen. The alternative is really at the moment to say to auditors, go and audit this. Auditors are going to say to me, so how long is a piece of string? Against what standard must I audit this? And in the absence of a standard, that provision is going to be inoperable. On the second point about the PI score, this is a really interesting thing. And the criteria are 4, and I'll share them with you. And they're really simple criteria. The first is 1 point for every employee. So in determining your PI score, for every employee you have 1 point. The second one is for every R1 million of liabilities, you get 1 point. The third one is for every R1 million of turnover, you get 1 point. And the last one is for every shareholder, you get 1 point. So the 4 parts are employees, third-party liabilities, turnover, shareholders. There are other complexities to it, but that's the basics on which the basis on which it is built. The one that is subject to the inflation growth in all of that is the one around turnover. And turnover is this, raced away. Businesses have grown in turnover, although fundamentally they may still be employing 5 people to serve fuel in the service station. However, the business now all of a sudden becomes a public interest business, or they're still baking bread, but the value of bread has doubled, therefore they now need to be audited, although the public interest has not changed in that business at all. So those are the criteria that go into that conversation. I hope I have discharged and answered the questions adequately. Thank you, Chairperson.
Thank you very much, Mr. Vanker.
A pleasure.
We'll now take our next report, which is, let me just check, from the South African Institute of Chartered Accountants, and it is Mr. Nomvalo. Thank you very much.
Thank you. Are we excused?
Yes, you are. You may
We
leave.
we wish you a productive further 2.5 days, Chairperson. I hope you have a very
Thank you so much.
Hello, Freeman.
Hi, Imre. Thank you, Chairperson. We really, as Imran said earlier, appreciate the interaction with the committee, the manner in which the whole process has been set up. We really appreciate that. I am accompanied by Thandokuhle Miyoli, who is going to be running the presentation for me. If you can share the presentation, Thandokuhle, as well as I think Milton Segal. I don't know if he's joined already. He's also one of the people that would have joined us. Thandokuhle, are you there?
Hi, Freeman. Yes, I'm here. Good.
Okay,
Morning still.
Please share the presentation for us so that I can walk the committee through it.
Okay, we don't
Chair,
see the presentation yet, Mr. Nomvalo. Can we just...
Okay, I'll share it from my side, if I can see.
Okay, but
there's the sharing button.
I think I'm just struggling. It says that only the host can share this.
But you are co-host now, so you should be
Okay,
able to...
all right. So I should be fine.
Oh, okay. It's not a very long presentation, Chair, so we'll be able to make up the time.
Committee Secretary, can we just share, sort out the sharing, please?
Chair, you should be able to share. Maybe we'll ask Margot if she can't share it for us, Chair. If there's a challenge.
Yes, yeah, that will help.
Just give us a minute or two, Chair. Thanks.
Okay, that's
Okay.
fine. We'll wait.
I see something is happening.
Yes, we're just waiting for slide mode, and then you can start. You can just indicate then when the
Yes,
slides.
you can please proceed to the next slide. So my name is...
We're not sorted yet, Mr. Nomvalo. Just hold on.
Oh, okay.
Margot? Okay, there we go.
Thank you.
Yeah.
Thank you, Chair. My name is Freeman Nomvalo, the CEO of the South African Institute of Chartered Accountants. And I'm accompanied by Thandokuhle Miyoli. He's shown his face on the screen shortly. And I believe Milton Segal is also joining us. We are an accountancy professional body. We've effectively existed in the country for 129 years, but only 43 years known as SAICA. Before that, we were 4 societies in the country. We now have over 55,000 members and associates. And our key designations is the CASA, AGASA. CASA is Chartered Accountancy South Africa. And the next one is Associate General Accountant South Africa and Accounting Technician South Africa. The CASA designation, Chair, just for interest, I will be announcing some developments on that designation tomorrow. So it will be some positive news for the country that I will be announcing tomorrow in relation to the CASA designation. The Institute services its members, Chair, who are in public practice. That some of them are auditors, as Imre talked about 4,000 of them. Some are in business, some are in academia, and some are in the public sector, and some are entrepreneurs. That's the range of members that we service. They are mainly key decision makers in their spheres of influence. They occupy positions as CEOs, managing directors, boards of directors, business owners, auditors, and CFOs. So we basically have our members in every sphere of society serving in different capacities. Our submission is therefore informed by the views of these members. We engage them, we pulled them together and had discussions, and the document that we submitted, the written document, and this presentation is a subject of that. If you can go to the next slide, please. What informs our submission is that there's no gainsaying that our economy is experiencing difficulties, of course, because of the energy supply, but also the issues of the ease of doing business is an important one. You can solve for the energy supply, but also it can still remain costly to do business in the country. So there is a need to review the Companies Act to make sure that it enables the ease of doing business. It reduces the compliance burden while still being robust in ensuring that businesses comply with good practices, but small businesses, while they comply with good practices, have got a fair chance of existing and creating employment, as we know, all over the globe. If you're looking to grow employment, you look to small businesses for that, and they tend to be more nimble in that case. So the cost of doing business becomes important, and the regulatory environment in place is very critical in ensuring that. We obviously acknowledge that the exclusion of the application of certain sections, especially in Section 26, is a critical one, and we acknowledge that. This principle of making it easy doing business is the theme that runs through our submission. So all of the points that we're going to be raising should be taken with that lens that we are applying. Can we move on? So the main issue that we think has got to help quite a bit is the point where the submission from the Independent Regulatory Board for Auditors ended. I'm not going to go over the issues that he has raised. This PIE score was implemented in 2011, and it has not been adjusted since then. So what then has happened is that without considering the inflationary considerations, businesses that have not necessarily grown in substance are still small businesses in every aspect, except that due to inflation, their numbers have now caught up with what numbers that have been put in the PIE score. They are now having to comply with a bigger burden from a regulatory point of view, and we'll talk to some of those. And this is an important issue that must be looked at. But of course, the interpretation of the terms that are used as indicators is an issue that might also require some review. The monetary measures of the PIE score obviously are subject to inflation, but the regulations do not provide a mechanism that takes into account this aspect. And then the creeping regulatory burden has been the order of the day. And we suggest that there should be regular intervals to assess the bar or to review those thresholds so that it makes the regulation easy and adaptable with the time. Can you move on, please? So what are then the results of the current PIE score? What these are used to? You determine whether an entity is required in terms of the Companies Act to undergo an audit. Again, Imre Imran spoke to that, whether alternatively, its financial statements should be subject to an independent audit. This, again, echoing the points that Imran said, may result in a costly exercise for entities that do not need to do so, that there is, in fact, at the time of the inception of this provision, there was no need for them because there was not much public interest. Companies which are required to be audited are subject to an enhanced accountability and transparency requirements in Chapter 3 of the Companies Act. So what follows from the PIE score are all of those requirements, which then means for entities to be able to respond to this, they have to make an investment, which then leads to the costs in those businesses and hampering their ability to create more employment for the country. The effect of inflation of PIE score over time has meant that some smaller entities previously did not have to have their financial statements audited, now need to be audited, and the burden has increased on them, such as the natural consequence of an unadjusted PIE score. Next slide, please. So we are proposing that the PIE score be adjusted as soon as possible, and that within the current legal framework, the PIE score that was 100 be increased to 350, and the PIE score that was set at 350 in 2011 be increased to 700. Again, just taking the inflationary adjustment over that period, you will find that these numbers reflect fairly where the PIE score should be today. So the following changes, following the changes to the PIE score, that the requirements in the Companies Act require a social and ethics committee in terms of the Companies Regulation 43 and the application of PIE score for business rescue in terms of Regulation 127. So all those will be impacted by the adjustment of the PIE score, and I think it would make the life much, much easier for the smaller businesses. Clarity should be included on how seasonal employees, temporary employees, and part-time employees. Imre already talked to the four criterions, and one of them being the issue of the number of employees. Now, some organizations may have economic activities seasonally, and therefore, when those economic activities take place, they are able to recruit and more people and get more people employed, or employ people on a temporary basis, and so on. These issues need to be better clarified so that they are treated fairly in the calculation, and entities are not affected by the PIE score when, in fact, the number of employees is only temporary and not a continuing one. If you can go to the next slide, please. So then there is an issue of the voluntary audits that has come in, and there is quite a number of points that Imre has talked to, and we as SAICA also in our submission talked to this quite extensively. And the bottom line on this slide, Chair, is that if the PIE score stays where it is, entities have to be audited when they did not need to be audited. Entities have to provide these disclosures, submit all of these returns in terms of the Companies Act. And that creates a burden on them. But at the same time, there may well be the reason why these provisions were put in place in terms of how companies respond to regulations. And we believe that in the case where there are other issues that government seeks to regulate, it should create a dispensation that allows for small entities that do not have connections with big companies and therefore are not being used as a way to get around the regulations. And this is a point that in my discussions with some of the people that are working in this area have raised. So a particular provision ought to be put in place to deal with that aspect and make sure that you make the burden much easier for the rest of the organization. And we believe that would be come in very, very useful, not just for small companies, but for ensuring that we create a business environment, a regulatory environment that enables small businesses to thrive, enables the creation of employment, and creates a chance in which our economy can then begin to rebound and grow again. We think that these provisions that we are proposing would go a long way in helping the economic space and creating better space for small businesses to thrive. There are obviously instances when small businesses would need to obtain finances from the banking sector, and the banking sector may have requirements for audits and all of those things. But if you have a blanket provision that does not make any distinction, entities may be forced legislatively to comply with these requirements, and making it costly for them, even though they might not need those provisions. Go on to the next slide. I think this is the last slide. Thank you, Chair. So we really are appreciative of the opportunity to come and present and put these views, and we hope that the committee will take these suggestions with the intended perspective that we intend them. We really want to contribute to making the cost of doing business in our country simpler, much more friendlier, and enable the thriving of small business sector. And if the small business sector can thrive, it will drive economic transformation, but also it will drive the much needed employment that this country needs. Thank you, Chair.
Thank you very much, Mr. Nombalo. Committee members, can we have hands for interaction with this presentation? Honorable Thring.
Should I proceed, Chair?
Please do so.
Thank you, Chair. Chair, I think that the comments raised in this presentation, firstly, had to do with the ease of doing business. One of government's responsibilities is to create an environment conducive to business. And I just wanted to confirm whether the South African Institute for Chartered Accountants believes that the legislation, the draft bill in its current form, would be the cost of compliance would be burdensome to countries and particularly to companies, and particularly to small business. Then secondly, you mentioned that the public interest score has been static since 2011, as our previous presenter has indicated, and that it is inflation to a large extent that has affected the outcome of this particular score. So, and you also indicated that perhaps the score should be reviewed regularly. So a simple question: how regularly do you feel the score should be reviewed? It may be difficult because inflation can be static. You could have inflation for 3 years within the band of 3 to 6%, and so not having that great an influence. So how would you recommend that the score should be reviewed? How regularly would you recommend that the score should be reviewed, and on what basis? Thank you, Chair.
Thank you very much, Honorable Mbuyane.
Thank you very much, Chairperson, for the opportunity once more. Chair, just clarity-seeking question from the SAICA. The PI score be adjusted immediately. I think we must get more understanding on those one and how can be able to assist the bill moving forward. And also the clarity should be included in how seasoned employees temporary should be treated for purpose of the PI score calculation. The other one is the increase in terms of the PI score as soon as possible. How is it going to assist the bill, given the fact that we still have small businesses in the process that need to be audited? Thank you very much, Chair.
Thank you. Back to you, Mr. Nombalo.
Thank you, Chair, and thank you to the members for their questions. The view that we take is that first, the bill would be helpful because it seeks to clarify various issues and make certain issues much easier. And therefore, to that extent, certainty is very, very helpful in any environment in ensuring that people know exactly what to comply with. Having said that, we think that if the score is not adjusted, the requirements that are in the legislation and which the original intention when in 2011 the PIE score was set was to make it that much easier for smaller business to do business. That benefit has been eaten away by inflation, and therefore with increased requirements that needs to be complied with by the small businesses, it then makes it burdensome. Without adjusting the PIE score, it definitely would be burdensome for small businesses. But if it's adjusted, it would then alleviate. Of course, you need to be reasonable with these things and say at what point, to what level do you make that adjustment? And we have made the adjustment to arrive at these numbers by looking at the inflation changes over the years. How regularly should this happen? If the bill creates a link to this number, to inflation, whether CPI or whatever, it would then help because there is an automatic requirement for that adjustment to happen on an annual basis. And at any given point in time, the regulatory requirement will reflect a similar scenario year on year because there has been an inflation adjustment. But obviously, government might say adjusting every year is too frequent, maybe do it every 2 years. But we believe that an annual adjustment would be feasible and can, in fact, assist. But we're not going to be too prescriptive on that. We think on the question, on Mr. Mbuyane's, Member Mbuyane's question, we think that the current legislative framework should allow for the adjustment to be made, which is why we saying it can be made immediately. But again, we know that Parliament may have more issues under considerations than we do as an outside party, and we don't want to be too prescriptive. But we believe quite strongly that the current legislative framework does provide sufficient regulatory framework to make it happen. Now, the impact of the PIE score on the requirement to audit, the basic point of departure, when we set the PIE score in 2011, we accepted the reality that there would be entities that would be left out of the audit. And as Imran had indicated, we accepted that on the basis that there isn't sufficient public interest in those organizations. Making the inflationary adjustment to make sure that number is reflective of that scenario is necessary. So the logic is still the same today when we say make the adjustment. We are intending to leave only those organizations that would not otherwise require an audit. But we believe to the extent that the public interest warrants, every organization ought to comply with the audit requirement. But we just are mindful that for those entities that are small, it should not be a requirement to ask them to be audited as such. Thank you, Chair.
Thank you very much, Mr. Nombalo and committee. It seems like we are doing good on time, and our other presentations are lined up, so we're going to try and conclude before we break, so that we break for the day. I will now hand over to, I think it's Ion. Yes, Ion, Stroke Association of Black Securities and Investment Professionals. And over to, I think it's Mr. Matabula.
Ms. Yes, Chair. Thank
Sorry,
you
it's
so much for
Ms.
the
I'm
opportunity.
sorry.
It's a miss.
My
You're
apologies.
forgiven. It's okay. I can't share my screen. It says
Okay, can you
only for
ask the
scan.
committee to sort out the presentation?
She is a co-host.
You are co-host now, so just try and share your screen.
Okay. Okay.
Just go to slide mode.
Okay.
Perfect.
And then do I remove all of you here? Yes.
Thank you.
I guess it's afternoon. Yes, afternoon, everybody. I am Timlambo Matebula from Eon Investment Management, and I am submitting the oral submission today in collaboration with ABSIP, which is the Association of Black Securities and Investment Professionals. And on the call with me, I believe, is my colleague, Sif Mohammed, who is the CIO at Eon Investment Management. Why is it? Yes. Just to quickly touch on ABSIP. ABSIP was established in 1995 to address the lack of representation of Black investment professionals and securities in the financial service industry. Their mandate is to empower Black professionals and Black businesses. Do I have to be the one doing that? Okay. Black businesses across the financial service industry. It has 4 organizational pillars, which are networks and linkages, engagement platform, continuous learning and development, and strong advocacy, which resulted into the collaboration that we had today, which forms part of their advocacy pillar. And then about Eon Investment Management, their value proposition. Eon Investment Management is a boutique asset management company that has been in operation for over 18 years, that currently manages over 21 billion asset under management for our clients. And we have a unique investment philosophy, which includes ESG incorporation into our investment process. And this has provided a solid investment process. And through our ESG work, we have won 2 awards, which is the ABSIP 2021 award for Best ESG Manager and the 2024 ESG Manager Award for Sustainable Asset Manager Award. And then through our ESG work, we have done significant achievements, such as being in the UNPRI since 2014 and maintaining a AAA consecutive rating for the period 2017 to 2019, and before they changed their scoring. But more so, our ESG work has also helped us avoid investing in companies such as your Steinhoff, EFH, and Transaction Capital. We did not hold any shares in those companies, and the primary reason was our ESG concerns, mainly the governance pillar of ESG. So in terms of ESG work, we do a lot of engagements, which is in line with what we've been doing, and we have been engaging companies specifically on their pay ratios and gender disclosure. And when we saw that the bill is up for amendment, we wanted to engage the parliamentary committee with this as well. So our comments are as follows, which are 2. 1, the disclosure of the 5-year historical pay ratios and gender pay gaps by major geographic segments. And what this means that if a company operates in different countries, we propose that their pay ratios and gender pay gaps be disclosed as per those, not only at a group level, but also at a basically country level. And this should apply to entities with more than 50 employees, including SOEs and non-profit organizations and the likes. And in terms of gender pay gaps, this should include equal work for equal pay, meaning 2 people of different genders who are doing the same job. This forms part of the disclosures. And the second commentary is on the definition of prescribed officer. And the current bill, there isn't a definite description of what comprises a prescribed officer. And in our written submission, we have written a proposed definition what this should be. But basically, this should be total remuneration of employees earning top 10% in the company. And the reason for this is sometimes prescribed officers or some other people might not be directors of the company or executives in the company, but they influence the company strategy greatly, and they form part of the top 10% paid people. And therefore, we would like the disclosure to be as such. And also the inclusion of subcontracted employees of the lowest total remuneration as well, because we'd find that subcontracted employees, in some instances, they get paid more than the actual company. So including this in the disclosure may significantly distort the ratios. And the benefits of this in terms of disclosure is that South Africa, we are one of the leading countries in terms of inequality, and it's prevalent in everywhere you go. And the inclusion of gender pay gaps and pay ratios will be a way of addressing this, as we know that the labor market is one way in which this inequality is perpetuated. And also, we can't hold people accountable for information we don't have. By having this disclosure, we can hold companies accountable, and we need the transparency as well. And also, this will be able to hold company board management in terms of track record. If we have a track record of how companies have been doing in this regard, it will help us greatly in terms of seeing the inequality hopefully being eliminated in our country. And also to give the board and management the opportunity to justify their gender pay gaps and pay ratios. This is not to say we are dictating, especially as shareholders, what companies should pay their employees, but rather they should basically provide commentary on what they think their pay ratio is. Is it fair? Is it not fair? Just a brief commentary on this regard. And then this just to provide how global leading companies that are South African companies that actually use the UK disclosure due to the fact that they're listed in the London Stock Exchange have been disclosing such information. And as you can see, they do disclose, but they only disclose in terms of the UK and UK only. And when we say by major geographic segments, it's if it's operating in different segments as well, disclose in terms of the UK, disclose in terms of South Africa. And that is basically a sum up of our presentation as Aeon Investment Management, and also in collaboration with APSIP. Now I can give back to you, Madam Chair, and just say thank you for the opportunity as well to be able to submit commentary, and we hope that this will be taken into consideration. And thank you so much for every speaker that has gone through me for doing it in a timely manner and sticking into timely manner. That's it from me in terms of my presentation.
Thank you very much, Ms. Mathebula. Members, can I check PC members for interaction with the report, with the presentation? Apologies. I'll take hands. No hands so far. It seems you did very well in terms of your presentation. Oh, I see there's Honorable Mbuyane.
Thank you very much, Chairperson. Let me at least appreciate the presentation and also acknowledge the empowerment of Black professionals, and also acknowledging that the company knows that in terms of gender parity, even in terms of pays and gaps and salaries, we are not equal. So I wanted to just clarity to say what is their process, or the process of the company ABSIP in dealing with this matter, because as much as they are dealing with professionals, they also have a responsibility to change the narrative in terms of the societal development around the issue of empowering the Black professionals. Thank you very much, Chair.
Thank you. Honorable Thring.
Thank you, Chair. Chair, let me also welcome the presentation, and I think it's encouraging to find companies that seek to address the lack of representation of Black investment and security professionals. My question is quite simple. What in your view, it's interesting to see that you avoided the Steinhoff fallout, and maybe just how was that possible? But my question is, what is your overall view of the effect of the draft bill on organizations like yours? Thank you.
Thank you. Ms. Matabula.
Thank you for interactions and thank you for the question. And in terms of, I'd also welcome my colleague to join in once I'm done answering your question. In terms of the first question, with regards to ABSIP, unfortunately, ABSIP is a separate organization and they would have to provide commentary on their own on what they can do. But as an organization, in terms of empowerment, we have seen it because they have different pillars. They have a national level, they have a student chapter level, and they have a woman level. So throughout all of this, there's empowerment, such as in terms of programs, creating collaborations, and more information is available in their website. I wouldn't want to put words in their mouth. Unfortunately, they could not join us today to speak. But yeah, they do empower Black professionals. And then in terms of organizations like myself, in terms of gaps, we as an organization, specifically, we have been engaging companies on this specific matter. And one of the reasons why they don't provide this information is because it's never regulatory and it's not available. And so when we've gotten the opportunity to come and bring forth to say that here's an opportunity to speak to Parliament to say this must be included, we took it. But in terms of a company level, we do believe in equal pay and equal work, and we do believe in pay ratios. And we go as far as I know, as an employee of my company, is that, for example, this is showcased in our employee. We have equity in the company. So we actually own, as employees, we own shares in the own company. That is something that's empowering as employee in the company. And I'd like to give an opportunity to my colleague if he wants to elaborate further in this matter.
Thank you, Ms. Matabula. Mr. Mohammed.
Yeah, yes, thanks, Temlando, for the very well-handed presentation on behalf of Young Investment Management in collaboration with ABSIP. So I think the first thing is we do what we practice, what we preach, we also practice in the company. That's important. So we do look at, pay ratios, gender pay gap, and we try and narrow the gap if there's any on the basis of equal pay for equal work. Obviously, we'll have differences, but we do that and we look at that. The other comment one of the honorable members asked was specifically about the question of sign-off, how we managed to avoid that. Part of the reason is because of environmental, social, and governance reasons, specifically governance. So for 12 years, we were not invested in sign-off because there was a trust issue. The other aspects was about valuation, low tax rate, not paying in the taxes, that they should have been paying. And then also the return on invested capital going down. So we were under a lot of pressure for about 9 years and 11 months. Why aren't we invested in sign-off? And eventually we were proven right. But it took us a long time to get there specifically. The other thing that I do want to bring to the attention of the committee is that for many years, we've been working for 7 years on pay ratio disclosures and gender pay gap disclosure by a major geographic segment and to show a 5-year history. We were very, very disappointed, I must say, that the gender pay gap ratio has been removed from the Companies Act. And I suspect it's, largely because of business lobbying potentially at NEDLAC. We don't know for sure, but that's what's happened. We can't let our mothers, our sisters, and our daughters still earn wages that's below their male counterparts. That's 50% of the population. So we call on Parliament and the committee to make sure that gender pay gap disclosure is included, but however, don't delay the submission of the bill. Make it an urgent and important change, and bring it in for not just for South Africa. Let's be a leading country globally when it comes to gender pay gap and pay ratio disclosure. And the important thing is prescribed officer definition must be tightened, because a lot of companies pay the real leaders of the company a lot more, but they're not directors, so they circumvent that also. So I hope we've answered the questions. If not, we will please alert us to it. Thank you.
Thank you very much, Mr. Mohammed, and thank you very much to Ms. Mathebula. We will now move on to our next presentation, which is from Corruption Watch, and it's Ms. Tsulu.
Good afternoon, Madam Chair and honorable members. My name is Nkululeko Chongo, and I'm an attorney at Corruption Watch. I'm joined by Ms. Refilwe Chulu, who is a legal researcher at Corruption Watch. We will be co-presenting. Corruption Watch is a public interest organization and an anti-corruption non-profit organization with an 11-year track record. We are an accredited Transparency International chapter, and our primary objective is exposing corruption, nepotism, abuse of power, and the abuse of public funds in both the public and the private sectors. We place specific emphasis on the promotion of transparency and accountability within the private sector and state institutions. Our focus areas in today's presentation, and for which we thank you for the opportunity, will be the extended timeframes in Bill B26, the beneficial ownership transparency mechanisms, as well as the role of social and ethics committees, both found in Bill B27. With respect to the extended timeframes for the director misconduct or corporate wrongdoing, we've noted that it's often complex to uncover and may require extensive investigation. There are instances where it may take time for the misconduct of the directors to be exposed, and it's because it's common for company directors to take advantage of more complex transactions and financial manipulation and deceptive practices to hide misconduct, and it will be less evident on the outside when an investigation is being conducted, which is why it requires more time. Corruption Watch is of the view that allowing for a longer time period ensures that affected parties have a reasonable opportunity to take legal action, and a shorter limitation of the period may be unfair to parties who are unable to discover or act on the misconduct at the time. I now move on to the second bill, Bill 27. In respect of this in respect of Bill B27, our first point to note is that the bill proposes some changes that are joined in with some of the changes of the General Laws Amendment Act, and I'll deal with the two in tandem. The advantages of beneficial ownership transparency include the promotion of tax compliance, combating corruption, provides for further accountability and oversight, enhances public trust by demonstrating businesses and individuals are adhering to legal and ethical standards, strengthens regulatory compliance, and facilitates international compliance, which aligns with global standards. What we noted, so that definition is in line with the General Laws Amendment Act, and generally understood to be part of beneficial ownership transparency. With the signing of the General Laws Amendment Act in 2022, we believe that it was the right step or a step forward in the right direction to ensure that there is adequate beneficial ownership transparency within the corporate landscape. Section 58 of the GLAA places an obligation on companies to submit records to the CIPC, thus disclosing the identities of individuals who are natural persons considered to be the beneficial owners of the company. What we've noted as missing from the proposed amendments to the Companies Act are two definitions at least. One is in relation to beneficial ownership. And we believe that beneficial ownership, the definition in the Companies Act should be tied in with the one in the General Laws Amendment Act to create alignment between the two. And then we also believe that the definition of public interest score should be included in the Principal Act. It's presently found in Regulation 26 of the Act. And with respect to the public interest score, it then assists in determining which companies need to have social and ethics committees. And we believe that that should be defined in the principal legislation and not in the subordinate legislation. So much like what was submitted or mentioned by the LSSA, we also believe that a lack of proper definitions could lead to potential misinterpretation of law. With respect to beneficial ownership transparency, we take a closer look at Clause 4 of the bill, Bill B27, amends Section 26 of the Principal Act by permitting holders of beneficial interests to inspect the register of the disclosure of beneficial interest in the company. Such a register only details the persons, be it natural or juristic, who hold beneficial interests that equate to 5% or more of the securities of that class issued by the company. We recommend that Section 55, subsection 3, as well as subsection 5, subsection C are amended and require that the beneficial owner is disclosed. If I could, by way of illustration, note the problem with the more limited definition. Where X, or an individual, is the beneficial owner of 5% shares in a company, and another person, B, seeks to verify the beneficial ownership information of a holder of maybe 15% of the shares, the beneficial owner of Y would in fact be the owner of shares in the company. So I own shares in a company and that company owns shares in another company. When you consider the register, you'll only be able to track to the company and not to myself. And any other shareholder wouldn't then be able to know that I am actually the beneficial owner. And it then makes the act somewhat opaque, or makes the beneficial ownership transparency more opaque than intended. Clause 4 of the bill also provides for access to the beneficial interest records of a company by persons who do not hold a beneficial interest in an affected company, subject to the payment of a charge. We welcome access to this information, but we note that it might place indirect limitations which were not intended. We would recommend that the limitations imposed by the requirement of beneficial interest be reconsidered, and we propose that Section 24(3) of the Principal Act be amended to require that every company must maintain a register of prescribed information regarding the natural persons who are the beneficial owners of the company, and that this must be submitted to the CIPC. We do not support the proposed amendments to Section 26(2)(a), as this could be a channel for fraud, corruption, and money laundering, insofar as it limits access to the information. I now hand over to Ms. Chulu, who will deal with the social and ethics committees.
Thank you very much, Ms. Chulu.
Thank you. Corruption Watch does note the need for social and ethics committees. And we know that it is imperative as it enhances ethical behavior and serves as an anti-corruption mechanism as they monitor compliance to ethical standards and to specific laws and regulations. In South Africa, we have the concerning trend where the social and ethics committees are unclear of their functions and purpose in their varying companies and industries. Clause 12, therefore, is imperative in ensuring that the social and ethics committees are taken seriously and provides for the appointment of the social and ethics committees by the shareholders. At Corruption Watch, we note that there are some missed opportunities in the bill. In terms of B27, we note that there's a missed opportunity for ensuring that the business and human rights due diligence are brought into South Africa's company laws so that South Africa is in line with our international obligations, international best practice, and to circumvent having to do a new amendment bill in the due course. We believe that this should be rectified. We also feel that the bill missed the opportunity to speak to the 3 pillars of the United Nations Guiding Principles on Business and Human Rights. And we know that these 3 pillars are the protection of human rights by states, the respect of human rights as a corporate responsibility, and catering for remedies for victims of business-related abuses. And business right due diligence involves identifying, preventing, mitigating, and accounting for how a company may affect human rights, both within its own operations and throughout its supply chain. They can contribute to counter-corruption through risk assessment, supply chain transparency, whistleblower mechanisms, stakeholder engagement, ensuring compliance with anti-corruption laws by promoting ethical corporate culture, and ensuring reporting and accountability. They refer to an obligation of conduct rather than an obligation of result. In summary, we believe that Clause 12 in Bill B27 is welcomed as a mechanism for addressing the uncertainty of function and purposes that the Social and Ethics Committee find themselves in practice. Clause 12A5, which speaks to the need of present remuneration reports, will also ensure transparency. We note concerning exemptions proposed by this bill, which could potentially be open to abuse. These must be strengthened as highlighted in our presentation. And as again I've said, unfortunately, Bill 27 has missed the opportunity to codify business and human rights due diligence into South African law. We do welcome the proposed amendments to Section 77 and 162 of B26 to amend the time bars in respect of proceedings to recover any loss, damage, or costs, and for bringing the application to declare a person delinquent. We've also identified the missing definitions in the bill, and these we believe should be included. That will be all for now from Corruption Watch. Thank you.
Thank you very much. Committee members, there we have the presentation from Corruption Watch. I'll take hands for interaction with this presentation. Members, Honorable Mbiani.
Chairperson, thank you very much. It's just a question that was asked by Honorable Pastor there, Honorable Dring, on the opportunity missed in terms of the stand-off campaign corruption saga. What is the view of the Corruption Watch and also the money laundering that has just happened? Thank you.
Thank you. Any further questions, members? Okay, I don't see any further hands. Over to you, Ms. Chulu.
Good afternoon. I'm not sure I fully understood the question from the honorable member.
Okay, let us ask him to repeat it. Honorable Mbiani.
Okay, thank you, Chairperson. Because it's from the previous presenters, Honorable Dring asked the question of stand-off saga corruption. So I'm just asking the Corruption Watch that it was not a missed opportunity to follow up on the issue of Steenhof saga, and where are we now in terms of the beneficial ownership, in terms of the transparency that the Corruption Watch is talking about. Thank you.
Okay, do you get it?
I think I somewhat do, Madam Chair. We haven't, well, we wouldn't say that there's a need to specifically address a particular act within the proposed amendments. However, we do believe that there is a need to enhance beneficial ownership transparency, and that this must be carried through from the General Laws Amendment Act into the Companies Act. So the greater level of transparency that can be achieved, the better and the more protection there will be for not only shareholders, but other investors. I'm hoping that this would answer the question.
Thank you. I think that concludes Corruption Watch presentation, and we now move to the University of the Witwatersrand Southern Center for Inequality Studies. And I think it's Ewan Yu who will present. Thank you.
Madam Chair, good afternoon, everyone. And I echo everyone's congratulations for convening such a seamless presentation. Thank you for the opportunity to make this presentation, Madam Chair and honorable members of the Portfolio Committee. I'm just going to slide mode. Should be good to go. So just an apology, this is prepared together with Professor Imran Balodia, who was not able to make it this morning. He has other commitments with the Competition Tribunal, but he sends his best regards, and we did prepare the presentation together. Secondly, this, unlike the others, we are only restricting ourselves to the remuneration disclosures that have been made, and we'll make reference to other things, but that's the only section that we'll be discussing. A bit about the center. So we're a research unit that's based at the University of the Witwatersrand, and the Southern Center for Inequality Studies is trying to engage with the fact that South Africa is the most unequal society, and to try and understand whether there is something about the nature of inequality in South Africa, and what are the causes, and why does it perpetuate itself in the various forms that it takes, to try and come up with solutions that we could then apply across the global South. And in particular, this work sits in very well with the Predistribution and Ownership Project that tries to look at, rather than waiting for fiscal transfers post taxation, to try and look at how the production system itself generates outcomes that could improve equity within the society. I mean, this has been said, but just to give a bit of context to when we say South Africa is very unequal and why these pay gap disclosures are particularly meaningful or useful at this time. We've had high inequality as measured by the Gini coefficient, and has in fact fluctuated post 1994, but has continued to be very high. Of course, there are variations within class and within racial settings, but generally the Gini coefficient was 0.67, which is very high. We also have, in terms of the wealth distribution, we have 3,500 individuals who own about 15% of all of the wealth in South Africa. And as a percentage, this is 0.01%. At the bottom, we have the 50% who are more indebted than own any assets, to the value of about 16,000. When we look at taxable income, we see there are very few individuals, so about 44,000 who earned over 2 million in 2021, and just under 50% of all taxpayers declare income of between 70,000 and 350,000. So these disclosures will provide a framework for us to track and compare performance over time. It'll give social actors evidence in order to advocate for change and to advocate for wages and bargaining opportunities with the different firms. As academic activists, we also hope that higher paid workers will also face some external pressure, and this will influence the increases that are received in subsequent periods of time. So what do some of these pay gaps look like at the present time? So this is just using publicly available information, and we're using the same kind of information that the bill proposes to track over time. And you can see it looks better or worse depending on what depending on the measure that you provide. But you can see that there's some differences. So whether the farms are owned locally or internationally farmed, whether they're internationally owned, the monthly pay ratio would look very different. And I should explain, as you'll see in the notes at the bottom, that the CEO information came from press reports, but the monthly figure, the average monthly figure that we're comparing came from Stats SA, and it's an average across all sectors. That's assuming an annual salary of about 283,000, which we accept is very high. But if we use the actual figures, then the fourth column, the figures would be significantly worse off than what they are. There are variations within sectors. Not included here are some state-owned entities that might also be required to report on some of these figures that had much lower ratios. So we do see that there is need for these pay disclosures, which we are firmly in support of. As we'll go through quickly in the next couple of slides, we think it's important that the legislation does not stipulate a ratio, but rather it focuses on making sure that there are adequate disclosures so that different stakeholders can engage with the information as they need to. Also, that rather than stipulating specific job titles, that it provides a range of earnings of people in recognition that sometimes a CEO or a CFO is not always the highest earning individual within a specific company. Including average and median is also useful because just the average will be subject to the outliers. So having higher earning individuals within the company will pull the average figure up, and it might not look as bad as it actually does, whereas the median is the 50th percentile, the earning at the 50th percentile, which is more representative. Also that it includes all salaries and benefits, because sometimes people's base pay could be very low and the short and longer term benefits are very high, and that's what skews the total earnings. So it's progressive that it includes both payments, also just that it includes both public companies and state-owned companies. And as a measure, we're looking at labor market figures in 2021, where about 70% of all workers are employed in the formal sector. Of course, not all of them are employed in public companies and state-owned companies, because majority are found in small and medium-owned entities. But as a measure, it does affect a large proportion of the population. But what we would like to see included in these amendments would be a stricter definition of who an employee is beyond just what's in the LRA Act. Because as other speakers have talked about, the other farms often have independent contractors. Farms often outsource hiring and hire through labor brokers. And so we need to be clear whether such individuals will be included as employees or not, even if they're providing the services at the firm that has to report on those disclosures. And later we recommend a way around this, but it's important to be able to see the employees on the payroll and those who are not, because sometimes it could be a way to get rid of the really low paid individuals if we don't allow for disclosures on both kinds of workers. We also think it would be important to include the title and the pay of the salary. So the salary of the lowest earning individual, just for openness, because in some of those individuals in those companies would belong to a trade union, and it should be easy for the shop stewards to be able to actually confirm whether or not this low figure that has been supplied is actually in keeping with the trends in the company. We're obviously not accountants, but just a question to understand whether the definition of pay and benefits, whether it's exhaustive enough. For example, what happens when someone is paid out when they leave halfway through the contract? Will that be included or not? Because sometimes some of those payouts could be quite significant. What about other expenses that the company then pays for these individuals on their pays on the behalf of the individual? Are those included or not? And maybe a way around that is to include a broad other and a definition of what that is, to try and make sure that the pay of these top individuals is as encompassing as it could be without being too prescriptive. We agree with ABSIP colleagues that there was a missed opportunity here to talk about gender dynamics and to try and actually track the gender pay gap in a meaningful and consistent way. Because, you know, as they said, and as we echoed in our own work, women tend to be working in the lower earning segments of the farm, and therefore they earn less. But also when they have similar characteristics in terms of education, experience, age, and all these other variables, they still earn less, which is the gender pay gap. And so we'd like to track it. Additionally, I mean, some of the firms that would be affected by this legislation are already disclosing some of this they're already doing gender pay gap reporting in the UK, for example. And so it should be easy for them to do the same in South Africa. And so we suggested the kinds of things we'd like, not just the pay, but commission and bonuses and things like that, the number of individuals, in order to get at how significant this issue is. Would like not just the pay, but how many of them are located across the different levels in the company. And for this, we could use the employment equity occupational categories in order to track and not make it as onerous on companies to then have to disclose in a new way. It's not clear the minimum employee threshold size, so it says public sector and private companies, but what about very large privately owned companies that are listed? What would happen with those? Other considerations from other countries that have similar legislation. In Germany, they're trying to make a connection between the pay gap of these top executives with the performance of the company and the country. So we began the presentation talking about how South Africa is very unequal. And then we move on to look at how these ratios of the average monthly ratios of the CEO to the lowest earning individual are extremely out of kilter. So some kind of paragraph or some kind of reference, some kind of comment by these companies that kind of ties the sectoral performance of the company with the country's outlook might be meaningful in trying to get them themselves to correct some of these pay gaps. The types of shares, share options that have been exercised in the sense of what's owed and what's missing. But also, as I said, in the US, firms that insource and outsource workers are forced to report on both in order to show what it looks like when everyone is included versus these who would be in South Africa, these very low paid individuals, what the pay gap looks like. Again, thank you very much for this opportunity and your time.
Thank you very much for this presentation, committee members. That's our last presentation for the day. Can I have an indication of hands for interaction with the presentation? Honorable Dr. Ntwani.
Thank you, Chair. And thank you to Wits for the presentation that they made on the analysis on the pay gaps. And I want to specifically commend them on the presentation and highlighting the analysis of the pay gaps across industries and across companies. So I think my comment is probably just that, a comment, because I think they just reminded us as to why we are here at the public hearing, specifically discussing the inequality of the pay across the various levels in a company, from the CEO right to the general worker. And so this presentation of Wits reminded us why South Africa is known to host the most unequal society in the world, and that it actually brings us back to what the amendments seek to achieve. And I want to just thank Wits University for their presentation. Thank you, Chair.
Thank you very much. I don't see any further hands. Can I hand it back to you? Ms. Ewenyu, I'm not sure if I'm pronouncing your surname correctly. My apologies.
Yes, no, you are, Madam Chair. Thank you, Honorable Chair. Honorable Member, for that. Thank you.
Thank you very much. So that concludes all our presentations for today. Thank you to everyone. I see most people have remained on the platform throughout the day. And thank you for the efficient way in which you did your presentations today to allow us to finish slightly ahead of schedule. So in conclusion, I want to thank you for all your inputs. It will be taken into consideration by the committee once we have completed all public hearings and once we start to deliberate on the inputs from the public on these two amendment bills. Thank you very much, and thank you also to the parliamentary committee team, and echoing the appreciation from various presenters on the efficient way that this process was facilitated. Thank you very much. We will convene tomorrow at 9 o'clock to take the rest of the presentations. Are there any announcements, Committee Secretary, before we
No, Chair, you have made the announcement that we proceed tomorrow at 9 o'clock. And we will communicate the program with them. Thanks, Chair.
Thank you. We stand adjourned.
Thank you, Chair.
Thank you, Chair.
Thank you, Chair.
Long live the chair.
Recording
Long live the
stopped.
chair.